I would like to call to order the meeting of the Speech Language Pathology, Audiology, and Hearing Aid Dispenser Board. I'd like to begin with roll call of the board members and significant others. Dee, do we have to rename the microphone? No, we're going to wait. Oh, so just speak loudly and clearly.
Okay. Dee Parker, speech pathologist, board member.
Marcia Raggio, audiologist, board member. Patty Solomon Rice, speech language pathologist, board member.
Allison Grimes, audiologist, board member.
Kelsey Pruden, DCA legal counsel.
I'm Nonchalet, board member, hearing and dispenser.
Debbie Snow, board member, public member.
Paul Sanchez, executive officer of the board.
And members in the audience may but are not required to introduce themselves.
Vanessa Kikina, HHP lobbyist.
Cliff Johnson, HHP Secretary-Treasurer.
Joe Doverick, hearing aid dispenser.
Toby Hill, president of HHP California.
Brianne Humphreys, board member. No. Anita Joseph, board staff.
Karen Robinson, board staff.
Thank you very much. And we do have a quorum present for board members. We are going to slightly reorder the agenda this morning. So we will begin, if you look at your agenda for the entire meeting.
Do you want me to go over it? Yeah, I can do that.
We can have a message. Yeah, go ahead.
Okay. We're going to reorder the agenda, and one of the important things that we have to cover today are the disciplinary guidelines and our proposed regulations. I want to make sure that everyone is, our minds are fresh and that we put as much focus into this topic as we can. So we're going to start with item number 15. After item number 15, we're going to go from item 11 through number 14. And then we'll take it from there and go back to item number 10. And I think we'll
You'll lead us along the way.
Yes, I will.
Yeah.
And then item 16, 17, and 18.
Correct.
Okay. Does everybody have a copy of the agenda? Would you like us to go over that again, or are we good?
Okay.
Okay. Great, thank you. So we will begin this morning with item number 15, proposed regulations for discussion and possible action. And Paul, if you would lead this discussion, that would be wonderful.
Yes, so one of our last teleconference meetings, November 17th, the board approved some amendments that incorporate the uniform standards into our Practice Act in regulation. And Kelsey's going to go over some of the technical changes that we need to approve today.
Yes, so this was completely my fault, and so I apologize. When we were changing the language to move the uniform standards forward and hold on to the disciplinary guidelines to work on them a little bit longer, I left some language into the uniform standards that actually named the disciplinary guidelines. So the only change is that, right, Karen, the only change is that we've taken out the reference to the disciplinary guidelines in the uniform standard regulation language. So I believe it was in section A. Oh no, it was in section B, right?
Yes, it was section.
It was in section B, and it said from the board's guidelines, and it actually referenced the disciplinary guidelines there.
Section B of.
Okay, wait, I'm sorry. No, it was the title of it, right?
There was a title, and then there was language referring to the disciplinary guidelines in section B.
Okay, so in section A, the title, and under, 15A, 15A, in 1399131.1, that is going to be now just uniform standards. It says, let's see, 1, 2, 3, 4 lines down, it says document entitled Uniform Standards Related to Substance Abusing Licensees 2017.
Yes.
I had left language in that referenced the disciplinary guidelines. And so since they're two separate documents now, that language has been removed. The name of this document, which we are incorporating by reference, is just the uniform standards. And then in subsection B, it also referenced the, no, actually, B is fine, because guidelines reference in 1399 and 131, which is correct. So it was that needed to be changed. So all I need you to do is approve this language since the...
And just so I'm clear, in 1399.155.1, where it says audiologist screening test renumbered, and then that is struck out, is that something that we need to understand?
No, that was just what was previously there. We're just using this number now, but that has since been changed. So it was the title many months ago.
Okay.
It's just delineating that used to be the title of this regulation section.
So really, you just need a motion to do the technical cleanup of the reference that was inadvertently left in when we last approved it.
Yes, that is what I need, and I apologize for that delay.
And even though Kelsey is falling on the sword, I think what would have happened is...
Please don't use that. That's a terrible message.
What would have happened
Well,
what would have happened is we would have presented this, and then it would have been... We're living in a very sadistic era. What would have happened is we would have presented this to the Office of Administrative Law, and then it would have been kicked back, and it would have just caused more delays. So by doing this, she's actually helping us prevent a lot of delays. So I think
delays that I caused, but yes. No, yes, because the board does need to approve any language changes, and since when I was looking at it for my review to move it forward to OIL, I noticed this and realized my mistake. So the board does need to approve the language, and we need that on the record. So,
Okay, is there a motion to approve the amended standards?
So moved. Second.
It's been moved and seconded. Is there any further discussion from the members of the public? Questions? Let's take a roll call vote. Dee?
Aye.
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 The motion carries.
Thank you, board
Kelsey.
members. I guess I can, do you want me to just move on to?
Yes, I'll ask Anita to come up, and if I could just give a brief explanation of what we are doing here. The next item behind 15B is the board's disciplinary guidelines. These are also incorporated by reference in our regulations, and as you know, we have spent a lot of time on this. This is not unusual for boards to spend a great deal of time on disciplinary guidelines. Hours and hours go into this, and this is a very important document. When we get to the point of discipline, if a licensee violates the Practice Act and gets to the point of discipline, these are the guidelines that are used to determine the appropriate penalty, and it's very important that we understand what the board's wishes are and how we apply discipline. So we are going to go over our very last, hopefully our last take of this, so that we could submit it as a rulemaking file to the Office of Administrative Law. And this is also, by the way, something that typically the Joint Committee for Sunset Hearing is very concerned about. The boards keep these updated, being that consumer protection is our main priority. So from this, I will let Anita and Kelsey kind of take it from here.
Okay, so the first part is under tab 15B. The first part is your actual regulation language. So not a lot is being changed here. We are updating basically the title of the disciplinary guidelines and updating the date to reflect this most recent edition.
Kelsey, can I just say one thing too? Since the last time the board members approved amendments, so that you're not confused and trying to wonder what have we changed, we've highlighted them. So when we go through this, you'll see them highlighted. Every board member has a highlighted copy, right?
Yes.
We may not have colored copies for the audience, but they're still highlighted. Okay.
Wait.
So you'll see as we turn through it, you're going to find highlights.
Yellow highlights.
So I believe we just don't see yellow.
It's
way back. Yeah.
When we actually get to the guideline document, you'll see that.
Okay. Yes. So So 1399131 and 1399155, they are identical. They just, one applies to speech language pathology and audiology, the other is in the hearing aid dispenser sections of the regulations. But what we've done is consolidated the two documents into one, and we've incorporated them by reference. So that is subsection A, which just shows the strike through of that 1997 version, which I will say I don't think that you guys are the oldest, but it's close. And so then in subsection B, that is also just delineating that when the board finds or the ALJ finds that there is a substance abusing licensee, that the uniform standards shall apply. Then there's some renumbering, formatting. Instead of subsection A, B, C, D, it's 1, 2, 3, 4, which is more in line with how it should be. And then the same happens in 1399155. So any questions on that?
I'm just wondering, maybe this is not necessary, but as I look at this, if I were just looking at this in isolation, I would wonder why we have two identical. So we don't identify that 131 applies to speech language pathologists and audiologists, and 155 applies to, does it just appear in different places in the
Yeah, it does appear in different places in the regulation book as well. And so
so it would be evident by where it sits in the book.
We may want to talk about, Kelsey, that when the boards were merged, this Business and Profession Code section was merged, but the California Code of Regulations stayed separate. So these are both cited in separate places. Now, the Bureau and the board each had their own set of guidelines. The Bureau's guidelines had not been updated since 1997. The board's guidelines have not been updated since 2004. As one board, we want to have one set of guidelines. It's actually very confusing when we're talking to the Attorney General's office and they're not sure what guidelines to go to and they're looking in the wrong place. So when you look through this, you're going to see that an entire set of guidelines is scratched out. That's the model disciplinary guidelines, which was part of the Bureau. And we're merging all of those guidelines into one document. Yeah, but the citations are in separate places, right?
Yes, so one, they're both in Title 16 of the California Code of Regulations. One is in Article 13.3, the other is in Article 13.4. So, and they are labeled as such, so it would be apparent if you went looking for them.
So when speech language pathologists or audiologists look for their guidelines, it's cited in their regulations. When hearing aid dispensers look for the guidelines, it's cited in their regulations.
Right. Speech language pathologists and audiologists are 13.4, hearing aid dispensers are 13.3.
So if I could just maybe push us through this, we'll look through that entire first section that is entitled Disciplinary Guidelines and Model Disciplinary Orders. You'll see that it's all crossed out. So we'll kind of have to page through this.
We're essentially just we're showing that we're getting rid of an entire document and that we're creating a new document. And for purposes of the Office of Administrative Law, you have to delineate what you are leaving behind and what you are moving forward with. So that's what all the strike through is about.
So we all want to get to this page here.
Okay.
So you can all flip to this page. And what I will do is I will go through the changes, and then if we need explanation, we'll have Kelsey and Anita kind of walk us through that. If we flip through, now once we're in that document, we're going to want to get to page 10.
Okay, so
we want to
then
get to page 10.
What is stricken on page 2, that's going to appear later in the document.
This is information that you have already reviewed and you have already approved. So we wanted to make it very clear what it is, what the changes were since the last time we spoke. I've been part of this process before where you have 4 different documents or 3 different documents and it can be really confusing to people. So I want to make sure that we'll understand. If we're looking at page 10 of the new guidelines, At the top of the page, it says optional probation terms and conditions. Does everyone see that? Are we all there?
Yes. Okay, wait, I'm sorry, just a quick, page 8 first, actually. There's not a highlight on there.
Okay.
But, so when the original one
Well, I'll make
licensed.
sure everyone's there.
Okay, sorry.
Because I think we're still. Did you find it,
Yeah.
Okay, so let's look at page
Yeah, I
8.
just didn't, I don't have, I think, the colorful head, no.
No, you did.
Something.
This up to page 8. Right. That's what we're
So we're 8 right now?
Okay, go ahead, Kelsey.
So, licensees, when, I sat down with your enforcement staff again, we realized that some of the licensees were actually missing. I know for a fact hearing aid trainee was missing out of it, so, it hasn't been shown via highlight, but, I just want to point out that all of the different registrations and licensees are now listed there.
So that's one of the changes, and Kelsey, if you see anything else that we may have not have highlighted, we can certainly try to catch everything. Now, if we turn over to page 10, just as a brief overview, when we're looking at terms and conditions, we have standard terms, which are on page 9. Those are bail laws, just among recovery of costs, probation monitoring, so on and so forth. Page 10 would be optional probation terms and conditions. And the only change on page 10 is optional term number 31, which is abstain from drugs and alcohol. We added to that abstain from marijuana since it is a mood altering substance. Did you have something else?
Yes, so I know, I cannot recall off the top of my head, but I do know that on page 9 and 10, some of these were changed. So I just want everyone to take a look at all of them and make sure that you're okay with the titles of them.
On the
Yes.
terms. Okay, so let's just go through the terms.
Okay.
If we go back to page 9, when we are putting together a decision or a stipulated settlement, these are standard terms. Standard terms, there's a severability clause, obey all laws, comply with probation. A lot of this is nothing that you will not have already seen. I think what we're talking about here is the titles themselves.
Right. So if you have an issue with the title, we can get to it when we get to the actual meat of it. But I did want to call attention that I do know I had that conversation.
Okay, so we covered page 10, adding marijuana.
Can I just ask something?
Sure.
The term abstain from drugs, is it already implied that even prescription drugs can be problematic, or should this say illicit drugs?
It's actually when we get to that section, we could actually talk about how it's worded.
Okay.
It should be defined.
Okay.
Yeah.
Okay, if we go to page 11, we're looking at standard term and condition number 2, obey all laws. This is that within 5 days of an arrest, a probationer should let us know. We added and/or violations of the law. Submit to the board or its designee in writing of such an arrest and/or violation. Any questions on that? Okay, number 3 is comply with probation. Respondent shall fully comply with the board's probation program and shall upon notice report to the assigned probation monitor, which is being specific, that in this case they're to report to our probation monitor. Number 4, the change of address, name, and contact information. And please let me know if I'm going too fast, or staff if you need to.
The rationale for 3 was also changed. Originally it had said something about the board, right?
I don't know, I didn't change the rationale.
I don't think we changed this since the last time we spoke.
Okay.
Respondent shall notify, number 4, respondent shall notify the board or its designee in writing within 5 days of a change of name, residence, or mailing address, address of employment, telephone number, and/or email address. So we want to also be notified of the employment address.
Is it clear what the and refers to?
So actually that was also added because originally it just said and email address. So I wanted it to be clear that it's if any of those change, not when all of them change.
Mhm.
But if you have an address change, you need to tell us. If you have an email address change, you need to tell us. Not if you decide to change everything, then you have to tell
I see
us.
what you're saying. Okay,
Yes.
that makes sense.
And these are the standard terms that go in everyone's,
Yes.
it's gonna be written out for them, I'm just.
Yeah. Oh, yes. So this is
And then we're not
exactly
gonna
what's
go
going.
to our disciplinary guidelines to find out.
No,
what
this
it
is-
Yes,
this is-
the standard
It's
information.
personalized for them.
Right. Yeah.
Okay. If we have no other questions, we can go to page 12. Very top, submit quarterly reports. Respondents shall submit to the board quarterly reports and verification of actions signed under penalty of perjury. These shall certify and document compliance with all conditions of probation. If the final report is not submitted as directed, probation shall be extended until such time as the final report is submitted and accepted by the board or its designee. The board is their way of communicating and notifying us that they're complying with probation, and we need them to comply till the end. Do you have anything else to add to that? Okay.
Not to that, but I was going to say, throughout the document, you'll see we had board before, and now we have board or its designee throughout, and I did
Okay, that's
highlight that
Yeah.
throughout. So
That's-
board
that
or
makes
its
sense.
designee or board, yeah.
That way that every time somebody submits something, it doesn't have to go to the board to vote on. You've designated it to your enforcement staff in order to handle the probation monitor in order to make those determinations.
Now, if we go to page 13, we have number 9, recovery of costs. What we added to that is the highlighted section that says failure to pay such costs shall be considered a violation of the probation order, which is stating explicitly that
That makes sense.
that's considered a violation. We
Within
go,
30 days.
yes.
And the bankruptcy was added back into, that was something that I had taken out in February. Subsequently, there was a case that maybe suggests that bankruptcy does not relieve a person of this debt. It's sort of not settled, but at least we put the notice in there that in the event the bankruptcy judge sides with us, they have been notified.
So I have a question. So for recovery costs, can they set up a payment plan?
Yes, so that is what it says in here. Any and all requests for payment plans shall be submitted in writing.
Okay, all right. So as long as they follow their payment.
Yes.
And they have to pay it 6 months prior to the scheduled completion of probation if they have a payment plan.
Any other questions on cost recovery or how payment works? We do try to work with our probationers, and sometimes these are large sums of money. Our goal is to get them working, to get them rehabilitated, working again. So we try to get a payment plan to work for them. And we try to collect most of the money early on in the probation to make sure that they're compliant with the probation. So we do have some parameters there. If we go to page 14 and
Can I talk?
number 12, yes.
Okay, so there's a little bit of a change mainly in, on page 14, function and license capacity and the tolling of probation for out-of-state. The title, the function and license capacity, the title was put here, it was tolling, we had two separate ones, tolling for in-state and tolling for out-state. So we took the same wording for the tolling in-state, and it's here under function and license capacity. And just took out, it was, part of it was duplicative of function and the license capacity, the first paragraph right here that's crossed out, which is that you should work in your license capacity. So that when you look now, the first sentence, respondent shall work during the period of probation, shall work in his or her license capacity. And so we just moved that, it's all the same wording here except for the parts that are highlighted, but it now has the title function and license capacity instead of two sections for tolling. So we have tolling for in-state and then tolling for out-of-state practice or residence.
Now, and prior to this meeting, the board decided that they wanted to have a minimum number of hours worked. And I think that's another question that Anita had. We wanted to make sure that the board still wants to have that minimum number of hours. So, because I don't know of any other board that does that. I think that's kind of unique to us as far as I know. In the 5 or 6 that I've looked at, at least. As we go forward, I'll just kind of go over the whole paragraph. Another important thing about tolling is tolling is originally intended, when you move out of state, you're really not under the jurisdiction of the board. You may have a license, but your probation is tolled because you can't be on probation when you're not working or you're out of state.
Yeah.
Sometimes people don't have employment, or they say, I'm not going to be working for the next 2 weeks. If you're a substance abusing licensee on probation, that doesn't give you a vacation from probation. If you decide you want to go on, you can't just say, well, I'm totally good this time, I'm not going to test. So we want to make sure that as long as you're holding a license and you're in the state of California, you're on probation. Whether it counts towards your probation because you're not working or not is another story, but you're still on probation. So I'll just kind of read through this. Number 12, respondent during the period of probation shall work in his or her licensed capacity in California for a minimum of 64 hours per calendar month. Respondent is required to immediately notify the probation monitor or designee in writing if he or she works less than 64 hours in any month. This time shall not be counted towards the satisfaction of probation of the probationary period, and the term of probation shall be extended for the period of time. Respondent is not engaged in the practice of minimum required hours. For the purposes of compliance with this section, work in his or her licensed capacity may also include, when approved by the board, as designated voluntary work or work in any non-direct patient position that requires licensure. If respondent works less than 64 hours per month, respondent shall be required to comply with the following conditions of probation as directed by the board: obey all laws, submit quarterly reports, comply with probation program, consumer restitution, recovery of costs, probation monitoring costs, and maintain a valid license. As directed by the board and if listed as a condition of the decision, respondent shall be required to comply with the condition to abstain from drugs, marijuana, and alcohol and submit to drug and alcohol testing.
So if a person goes on vacation for 3 weeks, and they haven't worked 64 hours, then their probation is going to get extended a month. Is that correct?
We haven't had a situation like
I've
that.
never had that come up. It's usually people don't have a job at the time.
But whether it be 3 weeks, or 3 months, or whatever period of time, yes, the letter of the law. If they're vacation, probably not. But if they're not working, I think that's what we really want to look at.
Oh, okay. So if they're on vacation and get paid vacation, that's as if they're...
Right. The next section says, for the purposes of this section, non-practice does not include the time school is out of session. If respondent is employed by and works in a school setting while engaged in his or her licensed capacity, respondent shall provide the board proof of employment and the school calendar within a week of the school year commencing each year. So what we were trying to say there, and that's something that we looked at last time we were here. You're on a 10-month contract with the school district. We're not going to hold that against the person. Marcia, did you have a question?
I was just wondering if you've ever had a case where somebody let their license lapse, maybe even accidentally, during their probationary status. Does that immediately revoke the probationary status?
We have had that. Go and talk about that.
Well, part of this language that we're proposing is that if you don't maintain a valid license, if there's a period of time, some people are just a little delinquent in paying their fees, so it maybe possibly doesn't get processed on time, or they're late. Their probation would extend for that period of time. Depending on the situation, that could be one of the violations if we're seeking to revoke someone. So, I mean, if you're talking a week, 2 weeks, it would probably not.
Typically, we would notify them that it's a violation of probation.
Right.
We have had some actual extreme circumstances where we've had people that were licensees and were really bad at keeping their license up, and as probationers, they were really bad at keeping their license up. So we've had some pretty unusual cases, but this typically isn't the case. Most probationers want to be compliant, and they're Johnny on the spot to take care of that.
I do have a point to bring up. So in that first paragraph, when they're essentially tolling and not working for a significant amount of time, this language is requiring them to essentially comply with almost all of the probation monitoring. However, it also extends their probation monitoring. So my question to the board is, what public protection is being served? I think that it's a little bit you're going to extend. They're not working, so they're not in contact with the public. And yet they're still having to drug and alcohol test if that's so needed. If that's their terms, they're still having to pay their probation monitoring costs. They're still having to comply with the probation program. Generally, what I see with other boards is you have to continue up your payment plans, your maintain a valid license, quarterly reports. However, all of the other requirements are not necessarily there while you're tolling, because the idea is that you're not practicing and you're not under the jurisdiction. So,
but if you're tolling, you're still licensed. Is that correct?
Yes, you still have to maintain a valid license,
Yeah.
right? So you're still under the purview of the board,
Right.
And you still have to submit those quarterly reports. You still have to do certain things. I just think that this language is a little bit. It might be a little bit extensive because, and I just need the board to think about the justification for this language, because that's what I'm going to be looking at afterwards and having to make sure that we meet that justification. And if somebody, for example, is not practicing, is not meeting this threshold that you've decided is the threshold where we want to keep you on probation, essentially, that we're going to toll you because you're not really working that much, then should you really be testing them for drugs and alcohol at that point, if you're going to be extending their probation later on?
So help me understand. If you're tolling, you absolutely have no practice at all, or you've just fallen below a particular.
So there are different types of tolling. There's the tolling where you're maybe practicing in a different state. There's the tolling where you're maybe just not practicing, either in this state or in another state. There's the tolling where you fall in under this scheme, where you've fallen under that 64-hour threshold.
So you've gone below 64 hours, but you're still working.
Well, I think if I
That
could
to me
just
is a distinction that
Right.
should be made.
let me just say something about tolling, because I think it's important that the board understand the rationale behind what we're doing. First of all, the 64-hour issue is a separate issue, and I don't think we want to confuse that issue with what Kelsey is talking about. Kelsey is talking about those people that, for whatever reason, are not meeting our requirement. I guess it is an issue because if you're not working the 64 hours, or if you're not employed at all, you may decide, you may be someone that works out of an agency and you're not employed for whatever reason. The issue that we have, and the issue that is somewhat unique to this board, in the years that I've been working in enforcement, I didn't have as many situations as I saw when I came. We had people that were on probation for a long time. I mean, they're pretty much taking a break from probation. They're taking vacation from probation. We found out that they were working in a school district, but they weren't necessarily telling us. So they said, I'm tolling. They want to have their license. When you look them up, they want the public to see that they're licensed with the board. That helps them. That helps them in their school employment to know that they're licensed. But they don't want to be compliant with the terms of probation. So in some cases, they have been tolling for years. No probation costs, no accountability to the board. Now, when we look at this, we look at consumer protection is our number one goal. I have to make sure, as your executive officer, that the people that are on probation are, that there's no consumer safety issues. Now, someone tells me, I'm not working during this time. In January, they're not working, but in February, they decide to go work for ABC School District. And they don't have to check back with us until another quarter or something, then I can't ensure public safety. That's where this is something that I think we have to be concerned about, because if someone is agreeing through stipulated settlement, or if someone goes to hearing and they're agreeing to terms of probation, they are agreeing to function in a licensed capacity. So I think it is important, especially when it comes to substance abusing licensees. I think it's important that these people, that we ensure that public safety is protected. So I think that's what Kelsey's talking about. This is probably this is very explicit. I think the distinction is that some boards don't put it in their guidelines, but they still enforce it. I mean, I know of 2 or 3 boards that do this, but it's not necessarily in their guidelines, at least yet. Do you have a question?
Have you ever had the circumstance where somebody was just unable to find a job, perhaps because they're on probation, and picked up some part-time job at Starbucks, and so they maintain their license, they're still under probation and that, but they can't work in their licensed area. Does that ever come up?
Well, I think that would probably be a tolling situation, and I would say that at that point they are not working with the consumers that your board is tasked with protecting. Mm-hmm. So at that point, the probation of them, the point of probation is to ensure that they are practicing with their license safely.
And I think Allison made a really good point at a previous meeting. We set the amount of hours at 64 hours. What if they're only working 20 hours a month? Where's the, I mean, shouldn't we just, well, I shouldn't say shouldn't, but there's a possibility that maybe we should just be looking at functional license capacity, period, and not set that number of hours.
Yeah, I mean, I would sort of say that this is a little bit confusing in terms of you're saying, okay, if you're under 64 hours and you're sort of going to be tolling, but really we're going to be doing the same thing probation monitoring wise. So is having that threshold really necessary when if somebody is using their license, whether it's for an hour a month or more, is that something that the board, they should be on probation active probation during that time? Now, I guess the counter argument to that is if they're only working, 30 hours a month, they're not coming into a lot of contact with the public, and if they, that might sort of speed up their probation. But again, you want to ensure that the public is sufficiently protected, and if you're having them comply with all of the, probation.
Okay, excuse me, we're going to take just a very short break just to look at our audiovisual setup for the morning. So hold that phone. So now I'm going to pass the microphone back to our duo down there to continue, and as questions arise, we have only one microphone, so be patient and we'll pass it around.
Okay, was there anything else that we were talking about, functional license capacity?
I think just my main question is in terms of practicality and in terms of public protection. Is this threshold of 64 hours something that the board wants to move forward with? Or is it something that maybe should be removed because if somebody's working 63 hours, they're still in contact with the public. And essentially this language would make it so that somebody who's working 63 hours, which in any given situation may not be any fault of their own, or may just be the way that they are choosing to practice. Oh, yes, yeah.
This is a really interesting discussion, and I'm wondering how other boards identify a threshold. Do other boards have a threshold, or is it just simply you're working or you're not working, and there's no number of hours? So what would your guidance be to be consistent with our goals of consumer protection and also so that we're not a strange outlier from other boards.
If I could just comment, Kelsey, I've looked at a number of disciplinary guidelines and I have not seen one. Maybe Kelsey knows.
I can't think of one off the top of my head. I think that if somebody is working in the capacity of their licensure, then the board has a duty. Oh, well, okay, so that's not my suggestion, but perhaps that if somebody is working within the capacity of their licensure, the board should continue that probation monitoring no matter the number of hours. And it may be that you do just have a very specialized practice area where this occurs. Okay, but Paul has a proposal.
Okay, so if you look at the section, functional license capacity, and I would suggest that from respondent, anything, all the references to the 64 hours be removed and replaced with the crossed out section up top that says respondent shall work in his or her license capacity in the state of California. And go back to that language. We could probably wordsmith the language, but the thought would be that respondent would work in his or her capacity and basically telling them that they need to maintain a license. Are there any issues with that? I asked Steph.
Yeah, I am.
Can I just direct a question to legal? I want to make sure that there's no one. Okay.
Is that more consistent with all the other licenses under the DCA?
I would say yes.
So that's good. Did you have a question?
Yeah, so I had a question because I understand that we are strictly concerned about the state of California, but if someone does move out of state, do we notify the state that they're, since we know that they've moved to another state, they have to tell us. Do we notify that state licensing board that we have someone on probation who has now moved to your state and is applying for licensure? Do we let them know?
Okay. I can answer that question. When they would contact us when they were applying for licensure, because they would already be notified that discipline was happened. Even if the applicant doesn't notify them, they would find out, hopefully on their own through the National Practitioners Database. Is that correct?
But they have to check.
Yes. We don't, because we have no way of knowing if someone moves to Montana and decides to apply for licensure.
Yeah.
If they contact us for a letter of good standing, we're going to let them know.
Yeah,
But we would have to be contacted.
that's what I thought.
Are there any other questions on section 12 from the board? Okay. If we could go to, pardon? If we can go to section number 13. This is tolling of probation for out-of-state practice or residence. Now, typically, tolling has been used for this purpose. And this reads, in the event that respondents should leave California to reside or to practice outside the state and will not be practicing in California. This is not for people that, cross state lines and work in both states. This is for someone that's moving. Respondents shall notify the board or its designee within writing 10 days of the date of departure and return to California. What we've added here is what they have to comply with. Term of probation shall be extended. I just skipped over that. This time shall not apply to the reduction of the probationary period. That's the tolling part. Or of any suspension. The term of probation shall be extended during this time, and respondent will be required to comply with the following conditions of probation as directed by the board. Obey all laws, comply with probation programs, submit quarterly reports, etc. Am I missing anything? You didn't cover?
The addition of tolling of probation shall not exceed 2 years was added.
And this is for the lifetime tollers that we've had to deal with.
Right. Lifetime tollers.
Well, being a little bit sarcastic, which I probably shouldn't be. We're talking about disciplinary guidelines. We're talking about people that have been tolling for years and years, for a long time.
So I just want to clarify. So their term of probation will be extended, but they still, even though they're practicing in another state, still have to comply with the recovery costs and all of that, or am I misunderstanding?
That's correct, as it's listed there.
Right. So,
Oh, sorry.
I was just wondering if the reverse situation occurs that do people on probation in other states come here to seek licensure, and would we license them if they were on probation elsewhere?
It depends on the discipline, but that would be grounds for discipline, for the board to discipline someone. So we don't automatically license. I think we look at it on a case-by-case basis. But discipline in another state is grounds for discipline here, which would lead to a probationary license, possibly, or a denial. Okay, number 14, voluntary license surrender. Am I only looking at the highlighted area here?
Just go over it quickly.
So on this one, I happen to notice there's also another highlighted area that should have been highlighted in the first paragraph. I don't know if I want me to read the whole thing.
I just want to know if there's anything else in the highlighted.
Yes, there's one more highlighted
Okay.
area, and it's in the first paragraph. And it's the third line from the bottom of that paragraph, first paragraph there, which is, so we're saying that respondent's license will, upon formal acceptance of the license of surrender, respondent's license will no longer be subject to the terms and conditions of probation, with the exception that any outstanding cost recovery is owed to the board, and the board may take action to collect the outstanding amount. So that part, with the exception,
Okay.
that was also an addition.
Okay, and then the very last section there, this is talking about voluntary license surrender. Someone decides, I don't want to comply with the probationary term. I want to turn in my license. And then the very last highlighted sentence there, any outstanding cost recovery balance must be paid by the respondent prior to the issuance of the new license. This is voluntary license surrender. Number 15, violation of probation. There's nothing there. Number 16, we just added the word registration. We're now on number 16, page 16, completion of probation, respondent's license or registration. If we go to number 17, the second paragraph, this is talking about educational course requirements. Respondent shall successfully complete the required coursework no later than the end of the first year of probation or earlier as determined by the board. You can ask staff if they have anything else to clarify. Okay, if we can move on to number 18, consumer restitution. There's nothing to add in that paragraph. There's a note to insert the consumer's initials, and this is when we are ordering restitution, we want it to be very specific as to who is supposed to get restitution. Typically, the victims are identified in the accusation by their initials. So this would specifically state that the respondent is to pay restitution to a particular person. This has been an issue that has been brought to the board before, where a probationer or respondent disputes who the restitution is supposed to go to. So this is meant to resolve that.
So this actual language is going to be insert consumer's initials. Is that language going to be inserted, or just the initials are inserted?
The initials.
Just the initials.
This is just to, sorry. This is just so when somebody goes to, if they were to go and just copy and paste, and then they would just insert there. So it's just to show where they would put the initials.
There's additional language underneath that paragraph that failure to pay restitution is considered a violation of probation, and the board is willing to work with the respondents to set up a payment plan. Number 19, submit to examination by physician. We had some some interesting timeframes, and we wanted to make it a little more clear. We want to get this information sooner rather than later, so we moved the 60-day requirement up to 30 days for an exam by a physician. And then we want the report within 45 days. 90 days can be a little long when we're talking about potential consumer harm. Number 20, psychological evaluation. There's just some specific language about the requirements of the actual psychologist or psychiatrist being licensed in California. And the approval part of it has to be approved by the board. That's something that the board members have asked me frequently, and I want to make sure that you understand. The psychologist, a lot of times where we have them provide us names of monitors, these things have to be approved by the board. We took out that there was some steps within 60 days, within 20 days. We kind of took out the unnecessary steps, and we just want to get to what the outcomes are. Again, we're being consistent. We got to get the psychological evaluation within 30 days, and within 45 days, we want the report.
And the biological fluid samples is moved to some other section.
The question was about biological fluid samples, and we'll go ahead and cover that when we get to that page. But yeah, yes. Okay, if we can move through this to number 22 on page 20. There we're talking about employment limitations. While on probation, respondent may not work as a faculty member or instructor in an accredited, approved school of speech language pathology or school of audiology, or as a continuing education instructor.
I like that addition. That's a great.
The question from legal is whether we should add approved.
Continuing education instructor.
What is approved?
I would say approved by our licensing board.
Really, so you guys approve instructors, is that right?
I think we should leave it the way it is, because if I think we don't want this person out there instructing, and we don't want to get caught up in any technology.
What about if this person? Don't we have to define specifically what type of continuing education? Maybe he's doing continuing education in skydiving. Are we prohibit this to do?
Legal counsel, do you have an answer to that?
That's why I suggested approved continuing education, because that's what you have jurisdiction over, but.
Approved be enough.
Or could we say continuing education instructor in their licensed capacity? Maybe they're instructing in their licensed capacity.
Under the jurisdiction of the school.
Yeah, because I'm just wondering too if it's. I don't know enough about the profession, but maybe Amron can help me. But so if you, I know there are a lot of manufacturers that do sort of continuing education that may not be approved courses, or maybe are just more informational but are called continuing education. I don't know how that all works, but is that something that would be problematic?
And I guess my answer to that is, if this were in the disciplinary guidelines, I probably wouldn't consider it a violation of probation to teach a skydiving course. I think that the spirit behind it is that the board's going to enforce this. So I'm not going to enforce someone that's teaching a class of cooking or something that has nothing to do with their license.
So we have to count on your word as long as you're the EO.
Well, I don't think it would hold water. The question is, do we have to count on my word? I don't think it would hold water, and that the Attorney General's office would file a petition to revoke.
And the rationale for not including the terminology of an approved continuing education instructor is because there are a large number of continuing education activities that happen in our state that don't go to the licensing board. I mean, you might be doing at a university a brown bag presentation for students about slipper requirements, for example, and it's not an approved, continuing education at the state level. But I wouldn't want that person giving that presentation if they're on probation. Yeah.
So to summarize, and if I'm hearing this discussion clearly, it's Paul's belief that leaving the language as is allows for reasonable discretion on the part of the staff and legal to know when this applies.
Yes, sort of. And my answer was more along the lines of if this were in the disciplinary guidelines and it was brought to my attention, we wouldn't take action on it if it was not in the manner in which it's intended. So I think I have one more question for Kelsey, and that is, do you have any suggested changes to this other than approved? I can see where approved could lead to some technical issues or some, and I would hate to get caught up in that.
No, I mean, the other thing, I guess, the opposite side of my argument is that as disciplinary guidelines, there should be some flexibility there and some fluidity, and so you don't want to necessarily throw in everything because you're ultimately going to forget something. So it might be best to leave it as is. I did just want to facilitate some conversation about it.
Thank you, Kelsey. If we move on, I don't have any changes on page 21, 22, or 23. If you have anything different in your notes, please let me know. Okay. Page number 14, at the bottom of the page is, I'm sorry, page number 24. At the bottom of the page, number 31, is the title that we refer to in adding marijuana to drugs, marijuana, and alcohol. That's set in that title. And then in the language, marijuana is also added. And then I go to page number 26, which talks about a billing system audit. And we're being specific there as to what we are looking at from a billing monitor. And in this case, we actually want a licensed CPA to go in and do the billing system audit. Are there any questions on the conditions and everything that we've identified? Or any other questions on this document? Anna?
I want to raise the point with Marcia that says, what about prescription drugs? And in this case, I will add, what about prescription marijuana?
Yeah. Good point.
Okay.
You have a question? What's that?
Yes, right above on page 25, right above where it says and marijuana.
Hold on, Karen. I think
Yeah.
Oh, here, I can
we can answer
okay, I can answer it. Okay, yeah, so I'll answer it for her. So it says, respondent shall completely abstain from personal use or possession of controlled substances. Okay, so page 25, very, very top, first paragraph. It says, respondent shall completely abstain from the personal use or possession of controlled substances as defined in the California Uniform Controlled Substances Act and dangerous drugs as defined in section 4022 of the Business and Professions Code, or any drugs requiring a prescription except when lawfully prescribed by a licensed practitioner for a bona fide illness or condition. So it does address that. I do want to go back quickly because I'm doing this via memory, but I believe we did change 27 to, and bear with me, I'm sorry, because on page 23, I am in the middle of doing disciplinary guidelines for 2 clients, so if it's not you, I apologize. But I do believe that we changed this just to reflect that it has to be the license, the examination that's in effect at the time has to be passed. The currently required, yeah. It's on page 23.
But it already says that, right?
So it does already say that. I just don't recall if that it says that in here because we changed it or if it was always in there. Okay. I just want to make sure that we cover all bases. I'm sorry.
Thank you. And just to be very clear, the expectation is that the board When we do it for this, we're approving the entire document as a whole. Marcia, had a question?
Sorry, you zipped by this so fast and I didn't want to interrupt you, but under 14, the last sentence says,
I'm sorry, what?
I'm sorry, it's page 15, item number 14, voluntary license surrender. The highlighted sentence says, any outstanding cost recovery balance must be paid by the respondent prior to the issuance of a new license. I'm wondering if someone's on probation, had a large cost recovery, $10,000 they owed us, they let their license lapse or they voluntarily return it in, and they never plan to practice again. Are they free and clear of that $10,000 recovery obligation?
Can I speak on that?
Sure.
So that's a very good question. So the paragraph above it, where I said I added something, or that something's added, and I'm sorry that I didn't highlight it, but the first sentence up at the bottom, it says, with the exception that any outstanding cost recovery is owed to the board, and the board may take action to collect the outstanding amount, covers that we can still proceed to collect money that's owed to us if someone surrenders their license. The bottom sentence is just clarifying that in the event we had never been successful in collecting the money and now the person wants to reinstate, there's a sentence that clearly states you must pay us before you can reinstate. So two separate, and that's why they're kind of separate here, so that it's no confusion, well, less confusion, I guess, so no confusion about the two. So it kind of covers the board's option to recover that when someone surrenders their license.
Would it be better?
Hold on, Hannah has a question. And then
No, I think for clarity, we should take it out. So they always can pay us. It's our discretion if we leave them open. Otherwise, it's conflicting.
However, legally speaking and practically speaking, once they surrender their license to the board, you have lost jurisdiction. So you have lost the ability to take action against their license and collect that way. So you are left with limited options, and you have to have the authority to collect those outstanding fines, which the board has limited. They do have some authority to do so, but it is limited. So I want to, I know that cost recovery is a huge issue, but I do want the board to be informed that practically speaking, there are obstacles to cost recovery, especially once a person has surrendered their license, because you have lost all that jurisdiction. You cannot then, continue to enforce any action upon that person. So it is the unfortunate part of doing business, I guess.
Emma, if I could just have a moment too. I think let's talk about reality, because what happens in these cases, in many cases, once you've gotten to the point of revocation, and let's say you've racked up $25,000 in cost recovery or $30,000, whatever that amount might be, there is an order that the person paid cost recovery back, but the reality is that we're probably not going to get that money back. The reason we put this language in here, and I think the very important reason to have it in here, is that this person may have a change of heart, they may become rehabilitated, come back to the board 5 years later, 3 years later, whatever that time frame might be. We want to remind them that as a condition of their voluntary surrender, you promise to pay the board back. So before we even review and go through all the steps of bringing you before the board, you've got to pay that money back to the board. And what that does is that eliminates that extra step for us. So this actually helps us in the process of looking at a reinstatement. Before you get to a reinstatement, there's all kinds of steps. You have to do a background check. You have to, the board staff have to go through all this investigative process. Deputy Attorney Generals are involved, legal counsel are involved, and then it takes up your time. So before we get to that point, any outstanding cost recovery balance must be paid by the respondent. So they have that understanding.
If I could just add to that as well, a voluntary license surrender will generally, it's always recommended that it's done through a stipulated agreement as well. And so having this language there, that ensures that that language goes into that stipulated agreement. And so in the event, and this does happen, where people do come back and petition for a new license, or to have their, to have a new license. So it ensures that then that can be enforced at the time that they are asking for a new license. So I would also say, practically speaking, that whether or not you keep this language in here or not, if there is a voluntary license surrender, that language will be going into the stipulated agreement, because that's what the Attorney General's office is going to do.
We have a question on this second. Is there any question? Okay. And again, I want to reassure the board that, we look at things from all aspects, and we look at things from a business perspective too. And I am concerned about getting cost recovery, and sometimes, without going into too much detail, we can be creative in ways of getting some of that, getting as much cost recovery back as we can. And I assure you that we do that. Okay, if I go back to, we're going back to page, we were on page 25, and Kelsey pointed out that the information on dangerous drugs and the California Uniform Controlled Substances Act is in here, and that's specifically why we specified marijuana, because there are changes in the law. But those other drugs that Marcia asked about and Amnon asked about are included in that. If we go to page 26, we're looking at, we covered page 26, I'm sorry. Yes.
We put in for billing system audit who are licensed in California, certified public accountants, but we also wanted to at least ask the board or for authority to add any other viable avenues for auditing. We know that one would be certified public accountants, but there could be other avenues or other maybe professions or something that would also do billing monitor. So we didn't know billing audits. So we didn't know if we wanted to keep that just exclusive to CPAs, or do we just CPAs?
Okay. So the question is whether we are concerned about billing monitors having the expertise to go in and detect fraud or any other types of schemes or violations that we would be looking at discovering.
Not knowing all the different types of licensed people, I'm perfectly fine with licensed CPAs unless there's some concern that there is an insufficient number of licensed CPAs. That seems like that holds to a pretty appropriately high standard.
Okay. Any other questions? Yeah. If we look now at page, yes.
Sorry, so to the billing system audit, this may be one of those times where you don't want to be as specific. I was just thinking of a situation where if there's Medi-Cal fraud, and the board is particularly interested in having somebody audit billings systems for Medi-Cal. I don't necessarily know that a CPA has that technical experience, and so you may want to leave more discretion to the board or its designee in order to approve somebody that has an extensive background in medical. I don't know if it works that way, but in that.
With regard to your example of medical fraud, I think we should rely on the audit and investigation department of healthcare services. They are specialists.
But in that scenario, there'd be nothing prohibiting a licensed CPA from getting information or working with an expert, let's say, in Medi-Cal. But still, it would be the licensed CPA that would be specified. So I don't see any reason to not hold to that high standard.
Okay, great discussion. If we go to page 28, now, once we are, these are the penalties for disciplinary actions. I think as Kelsey pointed out yesterday, this isn't punishment, these are penalties. And we want to make sure that we've identified, what we were struggling with is consistency and identifying minimums that our actual minimum. Sometimes our minimums were 5 years, and we didn't want to be too restrictive. We want to make sure that in some of these cases it's appropriate. So we only made a few changes, as I recall, and maybe Anita, you could just flag me as I go through them one at a time. So the very first one is the general violation of unprofessional conduct. Unprofessional conduct is that violation that is usually part of most accusations, and we brought down that minimum. We brought it down to 18 months. Is that correct?
That's what's existing.
That's what's existing. Okay.
We have changed it and then brought it back down.
Okay.
One more thing about that.
And right underneath that, there's a note. That's what we added, and I'm sorry I didn't highlight that. And it shows on a few of these that says note, mitigating factors of this offense may warrant public approval. So when you have your minimum and your maximums, we didn't necessarily want that every minimum would be public approval, but there may be some situations or circumstances where that may be, if it's a possibly, let's say, a very general unprofessional conduct, a very, maybe, I can't give an example now, but maybe a very general, not a significant and no, consumer harm type of a thing.
And just to be clear, a letter of public approval is discipline. It would actually be on the licensee's record. It's not just us sending them a letter. It's not like a letter of a suggested letter we may send someone when there's a complaint. This is actual discipline, a letter of public approval. So as Karen pointed out, that's not underlined because that's not a change. We had discussed changing it at our last meeting, but we wanted to stick with 18 months. Now, if we go a few sections down to unlicensed practice or false representation, that is 3 years. The minimum is 3 years now. And now I'm moving along to page 29, right? Did you have anything on page 20?
I'm sorry. One more thing on 28, unlicensed practice or false representation. This has been, we're combining the hearing and the speech and trying to combine it all together. So remembering what's new, what isn't, or what's been moved. So we were also trying to condense it so we're not looking twice in the same section, one for hearing and one for speech when applicable. And so the codes, you see the sections, codes, right under the title. So 2538.20 and 2538.30B. We added those here. Those were for hearing. So it was already a part of the other, our penalty section, but it was a part of the hearing. And we're trying to merge so that these would read more smoothly and not be duplicative, one for speech and audiology and one for hearing.
So let's just talk about the consolidation part. So what we've done there is we've consolidated the codes. And the way this works is everything has a title. The titles are not as important as the actual code sections that are cited underneath. So if they're related, we stuck them in one section. And in this case, unlicensed practice, false representation are very similar. Minimum requirement was 3 years of probation for that particular, for those offenses. Anything else? Okay. Now we go to page 30. Is there anything on page 29 before I go to page 30? Okay. If we go to page 30, the highlighted sections, unprofessional conduct, corrupt or abusive act against the patient. The minimum there, we had already changed it, but we added as a minimum term psychological evaluation and the limitation of serving as a supervisor, the restriction from serving as a supervisor. Number 30, unprofessional conduct, incompetence or negligence. The minimum, we changed it back to 3 years. We want to make sure that we have a 3-year minimum, and we added as to that minimum educational courses, the restriction of serving as a supervisor, and a practice monitor or billing monitor. Now, if you go to page 31, we are in disciplinary act by another board or bureau of the department or foreign jurisdiction. I think that was one of the questions that we had earlier. We just wanted to make sure that that's noted in the title. Right underneath that, another title change, sexual abuse or misconduct with a patient or a client. And we added as a minimum term their psychological evaluation and the restriction from serving as a supervisor. Sure.
Just as a general point of clarification, we're talking about maxima and minima. Do we have any leeway to put something in the middle between maximum and minimum? Or is that, it's either one or the other?
No.
Okay.
So these are guidelines, and I think, when we're talking, a lot of times, Kelsey, as legal counsel, always reminds me, these are guidelines. You don't want to have guidelines that you have to deviate from. Boards have been held accountable for consistently deviating from the guidelines, but they are guidelines, and there are times where there are exceptions. We want to try to come up with guidelines that allow us to be consistent in our discipline. Any other questions before I move on to page 30? We're done with page 31. I don't see any changes on 32 or 33.
33 has a 3-year probation.
Oh, thank you. Well, actually, I think, okay, there's some highlight changes. Let me go back to page 32.
Oh, yeah.
32, the minimum there is a 2-year probation.
Looking back at that one, we have 2-year probation. It was initially 2 years. Some of these we were also just looking at again and just wanted you to revisit what your minimums were. And this was one that it was initially 2 years. At a prior board meeting, it was lowered to 1 year, but we just want clarification on do you want that as 1 year or 2 years. This is the temporary licensee as a sole proprietor, manager, or operator. That's under the hearing dispenser.
Okay. So we're recommending 2 years.
I'm sorry.
So we're recommending 2 years.
Okay. And just so that I'm clear, you just re-emphasized that these are guidelines. So it is within the board or staff discretion to actually, for whatever reason, to do a 1-year probation. I mean, if this is a guideline, can you go below the minimum?
Yes, so I think Anita just figured out though why the board changed it, and I now suggest that we change it back. This is the actual statute that's being violated is Business Information Code 2538.30, and it's limitations on a temporary license. So it says a temporary licensee shall not be the sole proprietor, manager, or independently operate a business which engages in the fitting or selling of hearing aids, and not advertise or otherwise represent that he or she holds a license as a hearing aid dispenser. But you have limitations on your temporary license for a hearing aid dispenser, which is 18 months. 18 months. So if somebody can only be a temporary licensee.
6 months. Yeah.
Well, right.
The other one is just 1 year flat.
Right. So how are you going to put somebody on probation?
Well, I think the important thing here is that this is all, the maximum is denial. So initially we may deny their license if we know that as a trainee, they're already violating the Practice Act. Sometimes the problem is 1 year of probation is not a very extensive probation to us for us to ensure that they're going to be a licensee that abides by the law. So I think that's why we increased it. Maybe it needs to be the maximum, the minimum needs to be what the term can be the maximum amount as a trainee.
Right, because that's assuming that they then go on to get, that they apply for a full license. But this to me, well, right, it's which is likely, but also you have to take action against the license or the registration that they hold at the time that they engage in that practice. So while you could file a separate disciplinary action against them when they apply for that license, if you are taking action against their temporary license, then it would not be recommended to put their temporary license on a 2-year
Right.
probation when they cannot hold a temporary license for that long. So it's sort of two different issues. But I think that is one where you could probably deviate. Because if you were, probably most of the time it would be that they have applied for the license and now you're taking discipline on the new license rather than taking discipline on the temporary license.
Can I just clarify? I'll read the code so that there's no confusion here. 2538.30A, a temporary licensee shall not be the sole proprietor of, manage, or independently operate a business which engages in the fitting or sale of hearing aids. B, a temporary licensee shall not advertise or otherwise represent that he or she holds a license as a hearing aid dispenser.
Yeah.
I'm not good at
A temporary license is somebody who's supervising. Do we address what is the penalty for supervising?
We would in a different section.
It will come.
Yes, it's specified different. This is specific to that. So I think if an ALJ, an administrative law judge, is looking at this, he's probably looking at, okay, he or she thinking.
Thank you. I was just thinking the same thing.
The administrative law judge is probably looking at this person, if they are going to allow them to have a license, they're probably looking at a probationary term that they're going to have as a hearing aid dispenser. So I think that's the dilemma here and how we address this. I think if there's I would ask the board to give us permission to look at this. If there's a technical limitation, a legal limitation of 18 months or whatever it is, that will be the minimum. Our recommendation is 2 years, but we want to comply with whatever the technicality we need here. What we don't want is for a judge to say, okay, now when you become a hearing aid dispenser, you're no longer on probation. I think we want to make sure that that person is being monitored by the board, because that person is already engaged in dishonest acts. So initially we are going to deny, but we want to give the judge some guidelines if it goes to hearing and how to rule in that case. Page 33, unauthorized selling of hearing aid to a person under 16 years of age. And the minimum there was 3 years.
This goes into part of the discussion of we wanted to make sure what the minimums the board wished. And it's for both the unauthorized selling of hearing aids to a person 16 or under. It was previously at 5 years, and so this would warrant any type of discussion or input whether the 5 years minimum. We had, many that were 5 years. We just wanted to make sure that that minimum was really the appropriate minimum, meaning the lowest that the board wished to go. So that's we have 3 years there. And also right above it, failure to make a physician referral. That one was 5 years, and so we were possibly considering the 3, but wanted more input as to where you stood with those.
Okay, so these are from the 1997 guidelines, and the minimums were very high for minimums. That's why we're recommending a lower number of years.
And I don't mean to be obtuse, but I want to be clear. These are guidelines. So even if the minimum were raised to 5 years, there would still be discretion to go below the minimum? Or is the minimum really the minimum? That's not discretionary.
Again, as you said, they're guidelines, and I think what we're trying to create is consistency. This is the minimum that we want the board to settle for, and this is the minimum that we would want an administrative law judge to apply as far as probationary terms. So this is a guideline. Obviously, there are exceptions to that, but typically we don't want anyone deviating from the guidelines, so we want to try to be consistent. Minimums should be minimums. We'll make sure that we note that. Okay. Going through page 34 and 35, I don't see any other changes.
Can I clarify?
Sure.
Just to kind of clarify, Allison, you don't have to do the minimum or the maximum. There is room in between based on.
Okay, the in between I get.
Okay. Yeah.
My question is, can you go below the minimum?
If the facts absolutely warranted a deviation, then yes.
Okay.
Again, they're guidelines. They are meant to have some fluidity, but as Paul has suggested, they are meant to maintain consistency among all of the users of the document, which include the board, ALJs, the DAGs, your enforcement staff. So it should be what the board would like to see in most cases as the minimum, with the exception being that very, very minor case that rarely happens.
Okay. I have a few more changes on page 34 and 35 that I want to, actually they're not changes, but we just want to kind of review them. And that is unauthorized dispensing of a hearing aid, remote acquisition. The minimum there, we were recommending a 3-year probation. Using the term doctor, physician, audiologist unless authorized. At one point the board had suggested 5 years, but we were trying to be consistent again with our minimums and make that 3 years. And then on the next page, on page 35, sale or barter of a license or offer to sell or barter license. We were discussing 5 years at the last board meeting. I think we want to be consistent with all licensees. These are applying to hearing aid dispensers. We want to be consistent and make those minimums 3 years, which would make it consistent with the speech, language pathology, and audiology side. And historically, if you look at both documents, the Hearing Aid Dispensers Bureau, those minimums were a little more harsh. They were at 5 years. And on the speech side, some of the comparable violations, the minimums were at 18 months or 3 years. So we're trying to bring consistency there.
Seth, excuse me.
Sure.
And I certainly understand the consistency that you're talking about, but when we look at the cases that come before the board, we have far higher percentage of hearing aid dispensers who come before our board for enforcement issues relative to the number of hearing aid dispensers we have licensed in the state versus speech language pathology, for example. So we're having more issues of enforcement with hearing aid dispensers than we are with speech language pathologists and audiologists.
Okay, I could maybe address that.
Yeah.
I think we're not looking at the quantity of cases. What we're actually looking at is that we're applying things consistently. I get what you're saying, and I think the different professions have different types. We see different types of violations across the board, and I think it's kind of the nature of what they're doing.
But you probably get what I'm saying. But so what I'm suggesting is that we might want to have, rather than be consistent with speech language pathology and audiology, we might want to have higher levels of minimum because there are more issues going on with hearing aid dispensers than there are with speech language pathologists and audiologists. Professions our enforcement issues are at a higher level for that particular. Yeah.
My understanding, though, that this majority of the violations for hearing dispensers are simple advertising errors. They're not egregious crimes, from what I understood.
Speech pathology is a protocol with that.
Okay. I think do we have anything? We have one microphone. Do you want to restore order?
I would just suggest that there is always an ebb and a flow to discipline cases, and so what may be what you see right now, you want this document to be able to last as well, and so you really want to be practical about it. and that, your hearing aid one is from 1997. That's been a long time that it's been around. So I'm sure there has been lots of ebbs and flows in discipline during that time. And so you also want to take a look at what the actual violations are when you're looking at those minimums and maximums.
Okay, now, Allison, that's our presentation. I think now we want to see if there's any other board discussion or public comment.
Is there any comment, questions, concerns from members of the public? And if so, if you would come up and grab the microphone. And is there any other board discussion on Paul's presentation? Okay, hearing none, I'll give you back the microphone. Or do we need a motion to approve all these?
I just have one. I'm going to ask that you bear with me. I have one more thing I want to point out, and that's on page 37. So if you can go back to the disciplinary guidelines and look at page 37.
That's the last page.
Yes, and it's very similar to what we pointed out. Improper supervision of the trainee. That minimum was 18 months, because that is appropriate for the types of violations that we might see.
Does this relate to what I asked you? This is related to what I asked you. I mean, if a trainee has done a violation,
Yes.
the responsibility of the supervisor as well.
And to be clear, thank you, not to be clear, there's also more serious violations. There's aiding and abetting unlicensed activity. So there's some differences there. This is more to the technical issues of improper supervision. So now, if there's no public comment, you're asking for public comment, right?
Yes, and I did not see a request for public comment. Let me make sure that I'm totally clear. Okay. So at this point, I would like to request that someone make a motion to review and approve the language and disciplinary guidelines for submission to the OAL.
I move.
Okay, Amnon has moved. Is there a second?
Sorry.
I'm sorry.
I wanted to make it very specific. So then you want to, here.
I have to say that.
I'm just reading it verbatim from my board book.
Oh, okay.
No, I don't have it the way we need it to be. But
I thought I was going to get it right for once.
you were on the right track.
So, to approve as amended.
Okay.
All right. I withdraw that first motion and ask for someone to make this motion. A move to approve the proposed regulatory action as amended and direct staff to notice the language for public comment without setting a hearing. Amnon moves.
Second.
Patty seconds. Is there further discussion? Questions, comments? Roll call vote on the motion. Dee?
Aye.
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 And the motion carries unanimously. Okay, what section?
We're going to 15C.
All right. Okay, advertising regulations. Back to you.
And I'm going to have Kelsey cover our hearing aid dispenser advertising. These are guidelines that were in the hearing aid dispensers regulations. And I think that there's been a lot of discussion over the years on this. And Kelsey's going to explain some of the issues that we've had and some of the suggestions that we are proposing.
Okay, so I want to start by discussing a little bit about the authority that the board has. Business and Professions Code Section 651 is a pretty extensive statute that sets out basically for licensees false and misleading advertising. So I know that there was some concern that maybe advertising, the board didn't have as much teeth as they wanted in order to enforce advertising. However, I don't necessarily agree with that legally. I think that section 651 gives the board great discretion and allows the board to bring sufficient actions of false or misleading advertising. And I don't necessarily think that extensive regulations will add anything to it, because at the end of the day, the accusation is going to say that the advertisement was false and misleading because blank. And that will go back to section 651, which says that a licensee shall not advertise in a false or misleading way. And it does give other examples of what can be included. It allows the boards to say that they want, a license number to be on an advertisement. It allows, there's very specific provisions about prices in section 651, and that if there is a reference to pricing, then it has to be an actual price. It has to be include various elements. It discusses reliable data. It's talking about certain things. I don't believe that 651 is in your book.
Yeah, it is.
Oh, it is? I was kidding. It is.
Maybe we could just take a moment.
Yes, so take a moment to review 651, because this is what
147.
147.
148.
So this is in the general B&P.
And we'll see comment. Just
Yes.
Okay, page 147, and what particular section of 147 do you believe addresses this adequately?
So it goes from 147 to 151.
Okay.
And that's the statute that discusses advertising. And there are very specific parts of it. Sorry, let's go. So there are very specific parts of it. And actually 150 and 151 don't necessarily apply to you. There's a lot of things about dentists and optometrists in here and things of that nature. But so I can give a few examples. It says one of the things, like, it can't, if it relates to fees other than a standard consultation fee or a range of fees for a specific type of service without fully and specifically disclosing all variables and other material factors. There's another thing that says any price advertisement shall be exact without the use of phrases, including but not limited to as low as, and up, lowest prices, or words or phrases of similar import. Any advertisement that refers to services or costs for services and that uses words of comparison shall be based on verifiable data substantiating the comparison. Any person so advertising shall be prepared to provide information sufficient to establish the accuracy of that comparison. Price advertising shall not be fraudulent, deceitful, or misleading, including statements or advertisements of bait, discount, premiums, gifts, or any statements of a similar nature. In connection with the price advertising, the price for each product or service shall be clearly identifiable. I mean, it goes on. So that's on page 148 if you wanted to see that. That was subsection 8C. There's a little bit more general parts of it that, a false, fraudulent, misleading, or deceptive statement, claim, or image includes a statement or claim that does any of the following contains a misrepresentation of fact, is likely to mislead or deceive because of a failure to disclose material facts, is likely to is intended or is likely to create false or unjustified expectations of favorable results. So there's quite a lot in here. Again, and then it says some of the things that boards can require. An advertisement can include a statement of the name of the practitioner, a statement of the address and telephone number that the office is maintained by a practitioner, a statement of the office hours, a statement of languages, a statement that the practitioner is certified by a private or public board or agency, or statement that the practitioner limits his or her practice to specific fields. So, what I did was spent a lot of time with this language and tried to model it so that I'm talking to Paul and your enforcement staff as well. I wanted to try, I know that part of it is wanting to develop some sort of guidelines in order to say that, well, this is false or misleading. So that's how I tried to change the language to say that it is considered false and misleading when this occurs. However, when doing that, I did have some issues with some of the very specific requirements that are in here. And the reason that I have some issues is, one, a little bit on clarity and what one person may define one thing as, another person may not, which I can kind of get to. It could be very. And then the other issue is that while commercial speech is not as protective of a speech as, let's say, political speech, it is a protected speech under the First Amendment. And therefore, there's a Supreme Court case that lays out 4 criteria that have to be met when licensing boards regulate commercial speech. And so in doing that, and there's quite a bit of case law on it, and quite a lot of California boards have been brought into it as well. So what I suggest as well is that the board maybe take a look at not having as specific of regulations, because on the one hand, I think that 651 is very specific, and 651 does give a lot of enforcement authority. That there is the risk of potentially creating a rather large and expensive, I guess, suit to be brought, a lawsuit could be brought. So I have noted the areas where I would suggest making more general language. That we can go over.
I'm sorry, you've noted these.
I have not noted them in there. I tried to massage the language a little bit. I'm going to talk a little bit about, and there are a couple boards within DCA that have had to do the analysis of that 4-part test that I was discussing that the Supreme Court has laid out. So the 4-part test is, I'll just read it from the case so you know, is that for commercial speech to come within the First Amendment, it is at least must concern lawful activity and not be misleading. So again, we already have that in 651, that advertisements can't be misleading. And it has to be lawful. That's not a hard threshold to meet. Next, it must be determined whether the asserted governmental interest is to be served by the restriction on commercial speech is substantial. So in many of the cases, it's a public health issue, and so the courts have cited that, yes, that is substantial. Now, when we get into hearing aid dispensing, we have to ask ourselves if all of the situations that we are trying to regulate are going to be considered public health risks. So,
how do you define a public health risk?
Right. So I see a little bit of gray area there in terms of this particular board. So that's the second requirement. If both inquiries yield positive answers, it must then be decided whether the regulation directly advances the governmental interest asserted. And again, if you have a public health interest or anything like that, you know, and you're trying to facilitate that, then that problem is rather easy to meet as well. The last one is the one that gives the most pause, and that is that it may not be more extensive than is necessary to serve that interest. So it has to be narrowly tailored to directly, it can't be more than is necessary to reach that goal. And that's where some boards have failed this test. So That's my long spiel to start this process. But I do just want to make the board aware that there are some inherent risks when we're talking about commercial speech, that it is a protected speech, and that there is a lot of case law out there, which means there have been a lot of lawsuits brought.
Yeah. I've lost my train. No, I haven't. I think I can pull it back. So I guess just so that make sure that I'm on the same page. I think what you are proposing is that we not move forward with modifications to the proposed language.
Yeah.
Okay, so because I thought I understood that you felt that that what was the language that was in existence was sufficient to address the needs for that you have in looking at a case of advertising. Am I going down the wrong road?
Let me just clarify. So you do need to promulgate regulations in order to implement 651.
Okay.
But they don't have to be as extensive to implement 651. I mean, if you look at a lot of other boards, they basically just say advertising shall not be false or misleading under 651.
Okay. Is there value to the entity that is seeking to do advertising? Is there value in having the regulations be rather explicit so that you, as board staff, don't have to spend a lot of time saying to someone on the phone, well, you can say this, but you can't say that. Or, no, don't say that. How about you say this? So the more explicit the regulations, wouldn't that help?
That's kind of what I want to address. So what we have, and is Kelsey's proposed language that would amend or update what is already in our regulations, what we have always referred to as a hearing aid dispensers advertising guidelines. I think the original intent of the guidelines was not only to serve consumers primarily, but also to help those that are dispensing understand what the board is looking at when enforcing advertising laws and violations. So from a perspective of the licensing board and the regulatory board, I have the law that already tells me what is unlawful and what is allowed, and when we have filed formal discipline or accusations or citations, we cite that law. Whether we do anything to these guidelines or not, I can still do my job, and I will still do my job. So the guidelines are helpful, but we are trying to be successful in promulgating these regulations, and Kelsey is trying to help us get to that point with her suggestions.
So what I am proposing is actually that you do move forward with the changes, and I have spent some time massaging the language to make it so that some of the issues that we have discussed are put into regulation and are a little bit more specific. However, I do have some problem areas that I will point out to you. So if we want to go through the language, I have my notes and I can kind of walk you through my thought process when massaging this language. So first is changing 1399127, the title, to advertising for the purpose of fitting and selling hearing aids. And that's just so that's an inclusion that, it's not just for the sale of hearing aids, it's for the fitting and the selling of hearing aids, to make that more clear. In subsection A, we took out licensed hearing aid dispenser to also include dispensing audiologists to that. So a person licensed to dispense hearing aids may be advertising, fitting, and selling hearing aids or other services authorized to be provided by such license in the manner authorized by Section 651 of that Business and Professions Code, the one we talked about. So that implements all of those things that are within 651, as long as the advertising does not promote the unnecessary or excessive use of such goods and or services. Because again, here with hearing aids, I wanted to incorporate both of those. So generally, I just want to give you an idea. Generally, a lot of boards stop there. That's the language that they have, and they sort of stop there. But we're going to go forward. So section B, an advertisement for fitting and selling hearing aids is false, fraudulent, misleading, or deceptive in violation of 651 if it violates any provision of Article 8 of Chapter 5.3 of Division 2 of the Business and Professions Code, and that's all your hearing aid dispensing statutes. So now we go on to the more nitty-gritty sections. So subsection C. So here I'm implementing, if you want to take a look, it's 651 subsection H1 and H2. That's on page 149. And so this will make the requirement that the name and established retail business address or addresses of the licensed hearing aid dispenser as registered pursuant to sections 2538.33 and 2538.34. And I've included those because those are the ones that require hearing aid dispensers to give that address to the board, to furnish that address to the board. So it should be the same address as what is on file with the board, or the name and address of the principal place of business of the licensed dispensing audiologist, because that is also a requirement of the board. The license number of the person licensed to dispense hearing aids, including the letters HAD or DAU as appropriate.
I have a question. It's just coming to me that for so many decades I was AU 457. Am I breaking the law by not saying DAU 457?
Under this, you would be.
Oh, no.
Take me away.
Or calls for revocation.
Wow. Off with her head.
Oh. That's hysterical.
I mean, if that's something that you would like to change,
only for me.
we can discuss.
With the exception of Allison Grimes, AU, blah, blah, blah.
It's too old.
But you know, the dispensing audiologist there is a separate requirement, so it should be distinguished, in my opinion.
But the number is actually attached to the AU license.
Okay.
The AU is a sub-classification of the AU.
So they don't really have to.
So you really don't have a DAC license number.
You saved me. Thank you.
Right?
Oh.
The license issued by the board is just AU, even though they are
It's A.
authorized to dispense.
Oh, I think my license says
It
A.
doesn't say.
It does.
Okay.
Sure. Oh, man. Goodness.
I went free.
I thought they were going to cart me away right now.
Spontaneous suggestion.
Okay.
I know.
So it says the board shall issue a dispensing audiology license to a licensed audiologist.
And the title of my license is dispensing audiologist, but I think that the identification is AU 457, in which case the license number, including the letters DAU as appropriate, really is not accurate because my license is not DAU 457.
Okay, so AU. Okay, yeah. But technically, under the law, it should be a separate license.
It's not a separate license. It's an authority to dispense, but it's not. I don't have two licenses. No more.
I think we're getting caught up on the title, but it is,
Yeah.
they have a license to dispense.
Right. It is an actual license
Right.
based under the authority of the statute. It is an actual license category.
But I think for the purposes of this, the appropriate
The title is
would
AU.
be AU,
Because of
whatever your number is.
Really low. Yeah. Okay, cool.
All right.
What is your
So now subsection D. So then I I've typed a language to sort of incorporate some guidelines, but to tie it back to that language that's in 651, which is that it's false or misleading.
I have another question. Back in section C, I can't even tell you. Number 1, item A, the title doctor when the degree is a non-medical doctorate. So does that mean an AUD can or cannot use the title doctor?
If it's in medical.
I believe in the past we had been advised that if you use the term doctor, you must identify that you have a doctor of audiology. It has to be identified what kind of a doctor. So I think that language would raise a concern among audiologists with an AUD degree or a PhD degree. So that may need to be clarified.
Okay. So we could change the language to say the title doctor when the degree is not a medical doctorate, and the doctor it is not distinguished or identified or the area in which the doctorate. I'm not a good wordsmith on the spot.
Okay, but there is some kind of a solution for that because that
Right.
question will come up.
Is there a comment? Motion?
I thought we used to have language that stipulated that you had to say in what area was your doctorate.
Right.
Do we not have that anymore?
So your old language says includes an educational degree but does not list the degree in and field, or includes the title doctor where the degree is a non-medical doctorate and the advertisement does not disclose that fact. Because in subsection 1, so that subsection A, the title doctor when the degree is not medical, falls directly under D1, which has an educational degree that does not specify the exact degree and field in which the degree was earned. And then the title doctor when the degree is non-medical doctorate. So if you said, so I'm trying to think, if you said Doctor of Audiology, you are putting the educational degree,
Okay.
and you're saying your exact degree and field in which the degree was earned. So it would not.
So then that subsection A wouldn't apply, or that
Right.
you wouldn't be running afoul of that subsection.
Right, because you would, if you spelled out that it's a Doctor of Audiology, you would be in compliance.
Okay, good.
Two, a job title or dispenser certification by a professional organization that is not clearly identified by the full job title or certification and name of certifying organization. And I believe originally, the last time we looked at this language, there was a lot more there. And I kind of took a lot of it out because there does need to be some. We can't be so specific and so narrowly tailored that I guess what I'm trying to say is there does have to be some work put on the actual consumer to check those things. So they need to be given sufficient information to check it, but we can't require that, the advertisement be so specific that it doesn't put any of the onus on the consumer whatsoever. Because I think that is a little bit, that isn't narrowly tailored to meet our need, and our need is to protect the public. And so if you give the public enough information and they choose not to go check out to see, what the professional organization's certification is about, then they have made that choice. But I think before the language included a lot of things about that type of certification and that it couldn't be this, that, or the other. And I think that is too specific and not narrowly tailored to meet the needs. So that's why I had changed the language to that. Oh, did you?
Oh, am I supposed to do something? That's right, it's almost 11:30. I hear what you're saying, and you can't put every eventuality into regulation. But at the same time, between the lines, I think what I'm hearing you say is then it becomes incumbent upon the consumer to Google, what does AUD mean? What does HHP mean? What does audioprosthologist mean? So I guess that's sort of an interesting philosophical question that you've raised. Like, how much responsibility are we putting on the consumer? How much responsibility do we bear as a consumer protection organization? So I think, in my mind, this is kind of a big discussion. And all that being said, we need to figure out what we're eating for lunch. So we're going to take a really quick moment to think
We need to
about.
start walking over to the restaurant.
Oh, okay. We need to go get
Can I add one more
exercise.
thing before we, just to clarify, what Kelsey suggested language is not much different from what is already there. What she's referring to changes that were suggested, and Kelsey's job as legal counsel is to help us make sure that what we are proposing is going to be able to get us approval from the Office of Administrative Law.
And not to.
Right. So what we had was includes abbreviation for job titles or job certifications as letters after a name where those letters do not represent an academic degree or credential. That's the right one that it replaced, right? So again, we are talking about a job title or dispenser certification by a professional organization that is not clearly identified by the full job title or certification. So they would have to identify that and the name of the certified organization. So we would just want that information.
Yeah. The language that was put forth at the last board meeting, or the last time that we had discussed this, was something along the lines of a job title that's not real, or it has to be a real job title, or a certificate that is based on XYZ. And so when you start putting those types of things, the clarity issue gets to be a little bit hazy too. Because what is a real job title? Who defines that? I mean, if you are putting out an advertisement and you say that this is a job title and you've made it up, but that's your business, you are entitled to name the job title whatever you want it to be. So it doesn't really help the board, I don't think, in facilitating the ultimate goals of the board. So that's why I just try to scale it back a little bit. Because also you don't want to try and throw everything in either. Again, when we're talking about disciplinary guidelines, you don't want to try and make it so specific because you're not going to think of every situation. And so you want to give yourself the ability, again, and like I said, 651 is very specific and then it's very general. Anything that's false or misleading, if we can prove that it is false, if in the accusation and at hearing we can prove that it is false and misleading or deceptive in any way, shape, or form, then that is going to render discipline. It's not going to be this that gets the discipline going necessarily, because all those facts, yes, are going to bolster the ultimate point, which is false, misleading, or misstatement of fact. So I just want to have you guys keep that in mind, that just because it doesn't necessarily have all the situations you've thought of or seen doesn't mean that the board can't take action on it. But I am just suggesting and recommending to the board that they take a less specific approach and a more general approach to these regulations, so that and find that happy medium of having some guidance, but allowing the board also to not have to think of every situation that occurs.
That makes sense.
Okay.
Okay. We are going to not adjourn, but go on hiatus
Break lunch.
break for lunch, and we will reconvene, I hope, before too terribly long. We said 45 minutes, right? Okay, so we are planning on reconvening at 12:15.
That was 12:30.
12:30. Okay, 12:30.
We said 12:15. We want 12:15.
I thought you said 12:30. Okay,
12:15.
Eat fast. Yes. And now that I've called this to order, let me find the order of my agenda, which we reordered. What are we doing?
We're still on the
We're still on the-
hat advocacy right now.
Okay, give me the tab.
15,
C. Okay, I was trying to imagine that we were going to go ahead.
16, what?
15 feet.
15, okay,
You
that's
said
still on.
15, 1-5 C. Okay,
Sure.
all right.
And we're still on this page where you
Yeah.
have your little notes down.
Yes,
about the
yeah.
areas.
Mhm.
You know, you wrote the little notes down about the
Oh, so I'm on there. So it, all right. Yeah, those, okay. All right, we are in 15C and we are continuing our discussion. Would you like to continue
I
with
will.
us?
Yes. So just to bring us back to what we were discussing, again, 651 gives the board the authority. And again, these are my recommendations as, you know, your legal counsel. I've worked with Paul and enforcement staff and my own supervisor to get to these. But as always, you are free to adhere or not adhere to my advice. So I wanted to.
So I'm just trying to go back and pick up. You had suggested that there would be 4 sort of guiding principles: lawful, not misleading, substantial, public health, and can't be extensive. I can't even read my own writing.
Yeah, it has to be narrowly tailored to the goal, essentially. So it can't be so overbroad that there is a more narrowly tailored way to get to your ultimate goal, if that makes sense. You can't say hearing aid dispensers cannot advertise because, you know, there's the chance that it may be misleading. We have to have language that is narrowly tailored enough so that it curbs that potential for harm, but isn't so overbroad as to, you know, ban all advertising or ban most advertising or things of that nature. That's an extreme example, obviously. So I'm just going to continue on with what my suggestions are, and then we can kind of talk about it if that's okay.
Yeah.
So we are on actually subsection D. 2 was where we had left off, the job title or dispenser's certification by a professional organization that is not clearly identified by the full job title or certification and name of certifying organization.
Okay, I'm still looking for D2.
Right under
Oh.
doctor.
Yeah, under the title doctor.
Thank you.
And so, again, and 651 also has a reasonable, prudent person standard built into it. So when I talk about that, you know, putting some of the onus on the consumer in order to check these things, it's a reasonably prudent person standard. So we have to keep that in mind as well. Would a reasonably prudent person be misled by this? If they have this information. And so that's where I went to the narrowly tailored enough. If we just say that you can't do anything, or if you have to have all these things, is that really narrowly tailored enough to reach our goal? Or is by providing these components going to allow the consumer to make that choice? So subsection E, an advertisement disseminated, and I use that word because that's what's in 651. by a licensed hearing aid dispenser is likely to deceive, mislead, or fail to disclose material facts for the following. 1, the advertisement is for a hearing test and does not clearly state that the test is being performed to properly fit and sell hearing aids. And that is pursuant to 615 as well as 253.11. And then subsection 2, the description of services in the advertisement is so broad as to violate section 2530.3b.
Can you give an example of what that might be?
Let's take a look. And so again, that does not necessarily need to be in regulation. You already have the framework for that. But when looking at the language that had been suggested at the last meeting, I tried to tailor it to that. So let me look up 2530. I'll get there.
Page 5.
Page what?
Page 5.
Oh, you know what? That's is that holding yourself out to be an audiologist?
Yes.
Okay, so that's what it is. So 2530.3 says what constitutes representing oneself to be a speech language pathologist or audiologist. So in that, an example of that would be, so subsection B says a person represents himself or herself to be an audiologist when he or she holds himself or herself out to the public by any title or description of services incorporating terms audiology, audiologist, audiological, hearing clinic, hearing clinician, hearing therapist, or any similar titles. So if the hearing aid advertisement were to have that and it was by a dispenser rather than an audiologist, they could be held accountable for, 1, holding themselves out to be an audiologist, as well as the advertising. But again, that is not necessary. You have the framework for that.
Right.
So for duplicative reasons, I would probably suggest striking that. You don't need it. But I did want to offer it to you because it had been something. I believe what the original language was something like you can't have the business name of hearing clinic without hearing aid. So I wanted to stray away from what people can title their businesses because that is, again, a freedom of speech issue. And the way that we can narrowly tailor it within the law is that they can't hold themselves out to be an audiologist. So if that is a part of their business name or if that is a part of the advertisement, then that is a way that the board could take action. But I wanted to take us away from you can't name your business XYZ. That makes sense. Okay, so subsections G and H are where I have the most issues. And that goes to rebate coupons, rebate checks. It also had preset appointment information. And that is because I think there's some clarity issues here. Like when I was talking to a couple enforcement, going back and forth about it, what rebate checks look like, what the preset appointment information looks like, what the reasonably prudent person standard, and what the harm is that the board is trying to prevent here. So again, I think that the bottom line is that if it's false, if it's misleading, if it misrepresents, if it induces a bait and switch, all of those things are already built into your statute. So you don't need to spell them out. You already have the mechanism for that. So to sort of try and envision what every rebate check would look like, or when in some instances there might actually be a rebate check involved. And I'm not familiar enough with the business side of that to know all those things. But again, having all variables, that's sort of the price thing again, and that is already built into the statute. So I just see that it could be potentially more harm to make these as specific as they are when crafting these regulations, because again, you have the mechanisms, and at the end of the day, the board will still have to prove that the use of this rebate was false or misleading or misrepresented in any way, shape, or form.
So are you advocating then that we defer all these rather specific variables and simply say you need to follow the law, and we're not going to write regulations for every way in which that law can or cannot be followed?
What I would suggest is that, I think that having the license number, having the address, that those portions of the regulation are necessary in order to implement that. But I don't think that I would suggest removal of these two and keep it and have a more general approach to it.
Of these two, you mean G and H?
G and H, as well as, I mean, if you could have the description of services in the advertisement, that subsection E2.
Can we put a statement including but not limited to, so we don't limit ourselves?
You could, but with regulations, they have to be clear enough that the person that is going to be affected by them can clearly understand them. So if you are making a list, you don't necessarily have to make an exhaustive list, but what I'm saying is, when I look at these, and again, I'm not part of the professional community, so I am an outsider, but when I look at this, I have questions as to, well, if this occurs, would that be a violation? If a rebate looks like this, would that be a violation? If a rebate had this information, would that be a violation? So if you do want to approach it in that way, you're going to have to be very specific, because the threshold in order to promulgate the regulation is that those that are affected by it can easily understand it and know what the requirements are. So that being said, with words like false, misleading, misrepresent, those are very broad terms, and so I think that you do limit yourself in terms of enforcement by specifying and making very, very specific situations.
Would it be possible that one might argue that if it weren't listed with this specificity in the regulation, let's say that the regulations went through just the way they're written, you can't do this and this based on this and this circumstance, would it then open the possibility that someone could argue, well, you didn't say I couldn't do it. So even though it would be implied by the statute, if it weren't in the regulation, would that actually potentially trip us up? I mean, we're dealing with known situations here, but who knows what's going to come down the road in a year or two. Mm-hmm. So are we limiting ourselves? Are we really better to fall back on the broader, knowing that going forward it may be more flexible to advertising schemes, if you will, that we haven't even thought of?
That would be my suggestion. Because 651 is pretty comprehensive, and it does give you a lot of flexibility. And again, at the end of the day, that's what the board's going to be hanging their hat on when they do bring an enforcement action, is 651, and saying that, this advertisement is misleading because, and then to list it out, and then they're going to have to prove that up. So whether they do that, whether you have it specifically spelled out in regulation or not, that it's still what you're still going to have to prove that. So it's going to be the same method of proving it. But you could, yeah, you could be limited. I don't necessarily. I think that the statute is very broad, so it gives you a lot of authority. But my concern with these particular ones is that, one, the clarity into the justification. And again, I'm an outsider, so I'm just sort of playing devil's advocate here. But this is how OIL will scrutinize it. What is the harm that we're trying to prevent here with the use of rebate checks? Is it that the rebate check it's not really a rebate? Is it that it entices somebody in? And is that really the harm, or is it what happens after the fact that's really the harm? Once somebody is in the store, that's really the harm. So those are the types of questions I had in looking at this. And again, and I know that there's a very specialized community here that we're discussing. And so again, with the preset appointment information, I understand the harm there. I can see the justification for that. But you may be limiting yourself in terms of yeah.
Okay, so when we look at that particular statement, I wasn't here when that first came up, but I have read that there was a concern that this was a certain tactic that was being used. At the end of that statement, we're talking about G, right? Yeah, G. At the end of that statement is that are currently available on that device is a false, fraudulent, misleading, or deceptive advertisement. And then directing, soliciting consumers with preset appointment information when the consumer has not requested such an appointment is a false, fraudulent, and misleading, or deceptive advertisement. So I think it might be helpful for you to know how we would apply 651, because all regulations have to have as a basis statute.
Sure.
That is,
Yes.
so I think there is already language in 651. So the purpose of this was to identify how this is maybe false or misleading. And just sending rebate coupons or rebate checks isn't false or misleading. Just sending people appointment reminders isn't false or misleading. Well, it might be misleading, but it's not in its own right fraudulent. We made an appointment for you, because I've got these arguments. Well, we actually did make an appointment for them, but they didn't make an appointment with you. So can you talk more about 651 and how we would apply that? Yes.
All the specifics that we are discussing today came from during the time accumulation of our experience, what is the mass of violations. We cannot cover everything, but we cover the majority. And my question is like this: let's take, for instance, age, preset appointments. If we don't have age written there, it would be easy for the board to prosecute, or we have age in to prosecute preset appointment. What do you think? I'm asking.
I think that it is the same either way, because the way that 651 works is you're still going to have to show, the evidence is still going to have to show that it was false or misleading or deceptive in some way. So the accusation would look something like, you violated 651 and or 1399127H by sending preset appointment information to consumer A when consumer A had not made an appointment. And then at the hearing, the argument would be that by doing so, the advertiser falsely misled this person to believe that they had an appointment when in fact they had not had an appointment.
I think a provider can easily defend itself if age is not there, because when he set a preset appointment, he does not say you have set up an appointment with us. It says we have set up an appointment for you. If you want to come, fine. If you don't want to come, fine. I don't think it's false or defeating.
Yeah, technically I agree, but we know that in the mind of an elderly person receiving this in the mail, there's going to be a sense of obligation. Oh my gosh, I guess I better go.
I know,
And that's-
I know, but
yeah.
I'm trying to prove it in the court,
Yeah.
that we
Yeah.
know.
Yeah, but
Yeah.
I think this coupon issue falls under the same idea of the manufacturer's suggested retail price. We all know how bogus that is. We all do. I think this language here that says you have to say what the manufacturer's suggested retail price is might be a help in that people will see 50% off is not very meaningful. I mean, it still leads to a very expensive hearing aid, even though, they're taking what seems to be a huge discount. So if you said, well, it really is manufacturers suggesting $7,000 and you're getting $3,500, is that really a deal? So I think the coupon falls in that same category as that. So we have to decide whether we're going to make changes to these particularly egregious things. I haven't seen much of that anymore. Maybe it's gone away.
Yeah, because manufacturers don't have MSRPs anymore, is at least my experience.
Yes, they do.
Oh,
Do they?
All they,
Yeah.
almost all of them have published.
I still see it. In advertisement this week. So, and if you force them, they'll tell you some number, I suppose.
Well, and like a lot of the MSRP can pardon me.
Oh, yeah, no, this is fine. Let's, why don't you take the microphone, thank you.
A lot of the reason that MSRPs exist is because insurance contracts require we bill MSRP.
Yeah.
So if it's not published, then this fraudulent billing. So that's where a lot of the MSRP stuff comes from.
Yeah.
If you guys could please identify yourselves too.
Oh, I'm sorry. Toby Hill.
Joe Goodrick. You can have a manufacturer, at least I have manufacturers, that will print out a MSRP for you. So if I have an invoice come, let's say for patient Smith, I could have that invoice list retail out sent to me with their hearing aids that would give that MSRP. So they are still available. There's a lot of, there's some companies that will not give you an MSRP, but you can have them printed, at least we do. Thank you.
Yeah.
Even if they're available, they're still bogus, and I don't even know how many consumers really believe it when they see that kind of stuff, and they say, "Oh yeah, that doesn't really." So we're not really fooling anyone. They know that's if you really said it's $7,000, I wouldn't be surprised. So I just have a couple of things I want to say while I've got the mic, and that is F. I'm a little confused about this because I see it, not confused, I see the intent of not offering some sort of research study, not offering yourself out as doing a research study, but what's the distinction when you see, and I see it all the time in my local paper, somebody advertising a field study. They have a new product, they want 107 people to come in, practically every week, 107 people to come in to field test this at some reduced price. Is that coming out as some sort of research study, or how does that fit into this whole thing?
My recollection in the past when we discussed that particular issue was that we all agreed that that was a tactic to get people coming into the door. It's not a research study. So I guess if I'm understanding the big picture correctly, so correct me if I'm wrong, you are making a suggestion at this point that we actually defer the regulatory language or delete the proposed regulatory language, and you're telling us that we are safe in the knowledge that the law is sufficient to prosecute anyone or to have a case on any one of these particular sales practices without spelling them out in regulation, and that whether or not they're spelled out in regulation, the ultimate arbiter is going to be the law and not the regulation. So I'm understanding that you're proposing that we actually not do this laundry list of you can't do this, you can't do this, you can't do this.
Yes, and so to just start with subsection F, sorry, I was looking at my notes, and I had actually recommended taking that one out as well, because I had a lot of clarity issues with that. And I think that stems from yours, because we can think of a lot of different examples that could occur or that may occur. How do you list all of them? How you define all of them? What is a research study? Because that is going to be the ultimate thing. That, in my opinion, F would not be approved by the Office of Administrative Law. Because what is a research? What is an identifiable research project? We haven't defined that. We haven't said that. It could be a term of art. It could be I know you're saying in our minds we all know that there is no research project, but how do you prove that? How are you going to prove that to the judge? And so what I suggest is that if you have the facts that would prove that saying a research project is in some way false or misleading, that the statute would take care of that and you would be able to prove that. And just because you have the regulation in place doesn't mean that you could still prove that an advertisement saying, come to our research project, we need 170 people, is not an identifiable research project, quote unquote, and you would automatically get disciplinary action taken against that person. I think.
I believe we discussed this issue before.
Oh yeah.
And at the time, I think I said that when a manufacturer put an ad like this, that says the provider put an ad like this, and the manufacturer really, if it's true, get something in return. I mean, he is soliciting to make a research. You need people to do this research, and said that if they want to do it, they should do it at no charge. So if you do a research, you want 107 people come, and we're not charging for the hearing yet because the manufacturer needs. So if you charge, you cannot do a research.
So once again, and I'm just trying to really distill what I think I'm hearing you say, I think that your recommendation is to not write not to not write, that's a little extreme, but to really strip out from the regulations all of these discussions, and we should feel safe in the knowledge that under the statute we will be able to hear or prosecute cases that are evidently or clearly false and misleading advertising based on what's in the statute, and that we actually should not go through a laundry list in the regulation. So would we have any regulation at all that would interpret on 651?
Yes, okay, so here's what my recommendation would be. I would recommend that you adopt subsection A, B, C.
Okay, wait. Okay. Subsection
A, B, C. D.
D, okay. And all of the items under D, 1, 2, or just 1, 2?
Yes.
Okay.
I would leave out E, F, G, H. You can incorporate I. Again, that's pretty much identical to 651. It does use different language. It sort of spells out what bait and switch is. Entice the consumer into a more costly transaction than the advertised item or service at the advertised price. So I would probably leave that. J, again, is pretty much identical to 651. You could leave that in.
Leave it in, you said. Okay.
And K, if you want to discuss that again with the manufacturer's suggested retail price, et cetera, things of that nature. But again, you do have very specific statute on what needs to be included with the price.
So you just have a problem with F, G, and H?
Yes.
And can I just comment on F? Oh, did you say E?
EFG.
Okay.
I guess I don't have a problem with E. I just don't think you necessarily need it. And again, that is a standard of OAL is duplication. So.
Okay, and then some of these things, like for instance, G we would be removing because it's currently in the guidelines. So if F read, it is a misrepresentation, going to F, it is a misrepresentation of fact when an advertisement
To offer the word.
Okay, when an advertisement to offer new technology or hearing aid is part of a research study, how about if we said, what if we said it is a misrepresentation of fact when an advertisement falsely claims? And then it would be up to the board to prove that it's a false claim. Because I think what we're missing here is that these guidelines, I've had calls when people say, let us know what to put in the advertisement. And I know there are some people that would steer away from the whole field study issue if they knew that the board was going to investigate it. And if it's in our regulation, specifically in our section of the regulation, that might discourage that from happening. So we would be saying falsely claiming we have statutory backing of that.
I don't think that it's clear. I don't think that what is your definition of a research project, an identifiable research project?
If it walks like a duck and talks like, I think all of
that
us
is
know
what we're
exactly what we're talking about.
So that, but we have to justify it to the outside party of OAL. So if you can justify to me what that is and define it and make sure that every single person that is going to be affected by it understands it, because I don't understand it. I don't understand what.
I'm about to grab it.
So that's my take on it, is that I think that there can be multiple interpretations of what an identifiable research project is.
I think that's up to the board to investigate. And a good example is we have cases that are public documents, accusations that were filed against licensees that made false manufacturers suggested retail price ads. So we were able to prove those, or we're going to have to prove them in a hearing. I think it would be up to us to investigate that it's false. And I'm, whatever that entails.
I have another that had another kind of ding ding moment. What I would suggest to the board in terms of some of these advertising, when you do have these cases come before the board and you adopt proposed decisions on certain aspects, that the board can then adopt them as precedential decisions. And that sends a clear message that we won on this case, and this is something that's not acceptable and that we will be moving forward. And that is something that you can, when you go to hearing or put in an accusation, that you can say we have this precedential decision that establishes that it is false or misleading advertisement to do X, Y, Z. So I would suggest doing that when the board does have these advertising cases, where you have one that seems to be the norm or seems to kind of set a precedent, that the board can actually adopt that as a precedential decision. It would then be published on your website, and then people could go read it and say, okay, if my set of facts are the same as this is what's going to happen to me. So I would strongly suggest looking into that as well. I think that would be a very good avenue in terms of the realm of advertising, to sort of establish norms and guidelines, rather than a regulation where it can get kind of hairy, and again, you have all these standards that you're going to have to meet, and I think that it would take a lot more massaging of the language to get it approved by OIL in terms of those subsections that I'm discussing.
So again, I would suggest that if we added falsely claims, when an advertisement falsely claims that the offer of a new technology, so on and so forth. I think G is up to the board to prove. I do see where H would be a problem. So
You're proposing, just so I'm clear, so that was F that you were referring to, the falsely
Yes.
claims. So leave F in with the falsely claims.
and leave G in
Leave
and
G.
eliminate H. And if OL rejects it and we can't justify it, then we can't justify it. But I think it's important if we can get it in our guidelines to help dispensers know what is acceptable and what isn't.
So then we're only proposing to remove H
And change G.
and change G and change F.
I don't think we said any. I'm sorry.
You think
Not change.
you
I'm
should
sorry.
F?
Change F, not G.
Yeah.
Okay.
I think Marcia had a comment.
I don't know if we can add other language to F so that those of us who do research for a living have no doubt whatsoever what a research study components are.
Yeah.
It's not vague to me at all.
Yeah.
That it is a matter of data collection, statistical treatments, conclusions, hypotheses, and so on. It's very clear.
IRB.
So we could, I don't know if we wanted to add that would be necessary, or I just don't think I'd have trouble defending what a real research study is versus this vague notion of a field study. If that's what you mean, we can't say that as a field study research, and we'd have to go defend that it isn't. Should we add language in here to say what it must be?
So then I would suggest then adding that language field. I would suggest adding, if that is the case, then I would suggest adding field research versus research.
I mean, I don't think it's any different.
Mm-hmm.
We could say field or research study, right?
Yeah.
I mean, a field study is research, so I don't see them as different.
I do on H. The reason I have an issue with H is because it says directly soliciting consumers with a preset appointment information when the consumer has not requested such an appointment. Directly, as Amnon pointed out, directly soliciting someone with a preset appointment is not false. Again, you could say, I know you didn't make that appointment, I set up that appointment. So I think that one would be difficult to defend. Did staff have any comments on that?
I have comments on some of the stuff.
I think that the only concern that with the preset appointment is when the phone call is, oh, you have a preset appointment, and then the consumer is like, oh my goodness, I do, I forgot, I better go.
I can address that. So if we received a complaint from a consumer and during the course of the investigation, we found out that the licensee lied to them and said you had an appointment when they didn't, that would be something that we would cite 651 or other laws against that person. We don't need that regulation to state that in order to enforce that law.
I was just going to say for that one, if the advertisement maybe didn't state that it wasn't, if it was clear, if the advertisement didn't state that the consumer did not set the appointment, but it is kind of misleading if it looks like to the consumer when they look at this, oh, this is like a reminder of an appointment that I have, as if they said it, but maybe they don't remember. I forget, I get reminders all the time of my dental and medical appointments. So maybe it's just the wording of it, because if it doesn't state, it just says if they send that to someone, but it should clearly state that this appointment was not made by you, but we're offering this appointment to you. That's kind of my input, if you were to want to keep that in the language. But I also had a question
It
back.
would need to be reworded.
Then it would need to be reworded, but the point would be so that the consumer would clearly state to the consumer that they didn't make the appointment. That's the part that makes it misleading, and they can assume that they've made it when they get this paper and they're thinking, oh, I have this appointment. Maybe I didn't make that appointment. So that's my opinion on that one. And I know Kelsey had made a recommendation that maybe E wouldn't be a part of the strike, but
E1, that's an issue on a lot of advertisements, so I'm not sure if we remove that, which is where it says it does not clearly state the test is being performed to properly fit and sell hearing aids. That comes up a lot in advertisements where it's not really clear that that's what the purpose of the person coming in is for. So I think it's important, and I'm not really clear if that's mentioned somewhere else. So that's my input on it. I think that's important. That comes up a lot.
So I guess then it really comes back to, we need to make a decision about to what extent we spell out some common false advertising situations, to what extent we spell those out of regulation, to what extent we rely on 651 to take care of all of these issues. And I don't know, I mean, we all know examples, we all have examples of all of these things being done that have misled consumers. From a regulatory and a legal standpoint, we rely on you to tell us what are the tools that you need to be able to effectively hear these kinds of cases. Is it more helpful to you if we have these examples in our regulations that you can point to help consumers or help dispensers? Or does this end up being a laundry list that if something's not on the laundry list, there's an implication somehow that, oh, it must be okay because it's not on the laundry list? So I think this is really sort of a philosophical question that I'm not sure that we can answer because we're not involved in the day-to-day workings of actually making this happen. So you all help us understand what's the better way to go forward for consumer protection in these really thorny areas.
We are talking here about how easy it would be to prosecute these cases, but I'm looking now on another aspect, which is how complaint come in. The complaint comes on this issue of advertising from consumer, but also from other providers. And now, if a consumer feel that he was misled or something, and he look at 651, it's so vague that he doesn't know if it was legal or not. But if a consumer or provider have this example in front of them, he made something against it, and now they will file a complaint. Otherwise, they will think it's not. That's another reason it will be.
It's a good point. So, Paul and staff, give us your best advice about what do you think is the most effective way to protect the consumer going forward in terms of relying on the statute or doing this laundry list of regulatory, of identifying things in regulation?
So I can answer it because I think I'm the obstacle here. So
No.
But Paul, I sat down with Paul, I sat down with enforcement staff to go over this, and so this is the language that I proposed based on what they have told me their needs are. I don't necessarily agree with it, or I've made my recommendations. But again, I also can see Paul's point of that, it might be worth a shot of getting it through OAL and trying or seeing where. The other thing is that if when OAL does a disapproval, let's say that it isn't clear enough, let's say they take a look at research project and say, I don't know what that means. Then they'll spell that out for us. And then we can take it back. We have the opportunity to come back and say, okay, then do we abandon this or do we define it? And then get it through. So I think there is a simple answer to your question is that I have worked with staff and Paul to come to this set of language, and I have massaged it in the best way possible, the way that I see it, and then had my little recommendations. But I think that it might be worth a shot to try and push it forward if that's what the board wants. So that's sort of where it is.
Okay.
So I think right off the bat, we need to reword H. If we're going to approve language today, H needs to be reworded because, again, sending out preset information, even if the consumer did not make the appointment in itself is not false. So we would have to state something like directly soliciting consumers with false appointment information or something along those lines. Could you give us guidance on that, Kelsey?
Yeah,
I just have a question too. So with this one in particular, I need help in understanding the harm. Because again, we have to go through this 4-prompt test.
Well, they're lying. They're lying to me. They say, you made an appointment and you didn't.
Okay.
We can't do that.
Okay. So the harm is that somebody comes into a store when they would not have. And is that a public protection? Is that
It's a deal.
and are we narrowly tailored enough to do that?
I think it's just a high standard of having a professional license. You're not allowed to lie to consumers and mislead them. So I think we have the right as a board to say you can't lie to people in this manner, and it's stated for them to help them. Emma had a suggestion.
the age, regarding age, we can have the wording directly soliciting consumer with preset appointments initiated by the practice or office provider. What is the name we're using?
Licensee.
Licensee. Okay. So directly soliciting consumer with preset appointment initiated by the licensee.
But that in itself is not false.
Yeah, because that's true. Yeah,
So
it's not
you-
true.
It has to be. It's a practice.
we're trying to state here that it's fraudulent or it's false. So Anita, if you want to just call it out, I could repeat it.
Can we just say what it says, directly soliciting consumers with preset appointment information when the consumer has not requested such appointment, and then just add in, and when it is not disclosed, or that the consumer has not requested an appointment, or when it's not disclosed the consumer has requested an appointment. That's what it's fraudulent.
Yeah, but that's fine.
When it's not stated on there that they didn't actually request this is just.
I think what makes it false is when you tell someone you made an appointment. So to tell someone you have an appointment alone is not false.
Right.
They really do have an appointment. I made an appointment for this consumer. It's a true appointment. I made it. I might be trying to mislead them into believing they made it, but it in itself is not false unless I falsely lead them to believe you made an appointment with me. So we would have to still prove it. Regardless of what we put here, we're still going to have to prove it in a case. So we want to make it legally defensible. So I was suggesting something along the lines of directly soliciting consumers with false appointment information. And I don't know if that is strong enough. What do you think, Kelsey?
What is false appointment information?
Yeah, so it
Then it's
is.
on me to prove it. It's on me to prove that it's false.
Yeah, but OAL is going to say these people are not going to know what false appointment. The people that you are regulating are not going to know what false appointment information is.
Okay.
Yeah, and it's not a false appointment. It just is an appointment that wasn't
Right.
made. It just wasn't made by the consumer. It's not a
Well,
false
what
one.
is this? With appointment.
And I'm wondering, to what extent can we, at this juncture, kind of reach a philosophical agreement about how we're going to move forward, and if we need to wordsmith in the regulations, that can we have a very small subcommittee that could work on this offline?
You could, but the board as a whole needs to adopt the language in order to file it.
Sure, and that makes sense, and we need to do that today.
You don't need to do it today, but if you, in order to move forward
I
with
got
the
you,
regulations, the
Yeah.
entire board does need to.
And that makes perfect sense. So I'm wondering if we could defer the final vote on moving forward,
If that's the
and then in
board.
the interim, get some homework done.
Quick process check. I think that we have plenty of work to do in the area of regulations. I can assure you that Kara's going to be very busy with the disciplinary guidelines. So if the board does not mind deferring this to another meeting,
Yes.
I think Alice's suggestion is a good suggestion. We have a hearing aid dispenser on the board, and we have other dispensers other audiologists that are
We have
dispensing audiologists.
dispensers.
So we can have two on the committee. I would suggest that we have a committee and that we go through this, and legal counsel can work with us, and we can flush it through. Again, we have guidelines, we have laws in place right now, but I think we could put a better product together. Especially, we had very good conversations today that would be helpful.
So I'll just,
I like that idea.
yeah, I like that idea. So I'll just say one more thing in that I'm kind of, I'm an educated consumer because I'm on this board, but I'm not a hearing aid dispenser. I would need some of the specificity, or else I wouldn't know that I was being cheated on. I just
If you were the consumer.
If I were the consumer,
Yeah.
here I am, an educated person on the board listening to arguments, but I'm not a hearing aid dispenser, and so I need a certain amount of specificity to even know that I'm being cheated on, what it is I'm being cheated on. So it's a very fine line between what's the Office of Administrative Law going to accept and what is enough information so a consumer knows that they're actually being cheated.
Yeah.
You have to have
Acceptance.
both
Yeah.
pieces of that.
I
Yeah.
agree.
Yeah.
Yeah, I wrote that down.
Yeah.
We gotta keep this.
Right.
What keeps them safe.
I think you just need a motion.
A motion to delegate to okay, good. Somebody make a motion to delegate to Amnon and Marshall. Yay, okay, to work on this.
We're talking about FGMH,
The
right?
entire.
Well, we're talking about,
All of
yeah,
it,
we're
right?
talking about that.
Well, just the 3-page document.
Yeah.
It's only two.
It's only two.
It's really
Yeah,
2 pages.
2 pages.
They're here.
Okay.
Yeah.
It's a page.
It's only a page and a half, yeah.
The other page that
It's just striking.
Okay,
15B. 15, no.
D, you can make that motion.
Yeah, 15C.
Here, pass that to
15C,
Mark.
okay.
Pass that mic to D so she can make the motion.
I'll make a motion.
I so move.
I second it.
Okay. Thank you. So it has been moved and seconded that the board requests gratefully the help of Marcia and Amnon to work on clarifying the language and streamlining the language, this proposed language, and come back to the next board meeting with proposed language that we can then vote on to move forward. Is there further discussion from members of the board or members of the public? Yes, please come forward.
Should I take a mic? Or?
Yes, please.
Okay. Cliff Johnson. I'm a Miracle Ear franchisee in San Diego area. I have 3 offices, and also I'm treasurer, secretary of HHP currently. Several of the things a couple examples didn't come up that I would just like to point out for your consideration as you further develop these regulations. I really like what Kelsey was saying about keeping it simple and just. I understand having examples, but boy, it makes it really hard when you make specifics. Anyway, the Business and Professions Code, if we look at C at the very beginning on the first page, the advertising by a person to a person licensed, I assume, to dispense hearing aids for the purpose of fitting and selling hearing aids shall include. The B&P code, as I read it in that book, the Green Book, says may. That's a huge difference.
So that is because it's saying that boards may promulgate regulations that require those things. So the statute is really giving the boards the authority to decide what they want to do. And so if we put may in here, then it would be discretionary. But we're saying no, the statute allows boards to decide whether or not they want that information on advertisements, and we have decided we do. So,
Okay, so here are some of the concerns that I have being a franchisee of an organization that's part of the largest hearing aid retailer in the world. Okay, that's one of the things. We have 1,300 offices around the country, I'm an individual owner. That's how it works as a franchisee. I have 3 offices. But I have to do things to whatever degree that the corporation, the way they market too. So I try to interface with them and let them know what's not legal in California when they do certain things, and they work with me. So some of the issues here, I'm concerned about number C1, the name and established retail business addresses of the licensed hearing aid dispenser, and then also requiring a license number. For us, that could become burdensome, especially when it relates to national advertising. So, for example, our company, Miracle Ear, buys internet ads for us. They also sometimes have magazine advertising that may be in a newspaper, let's say, Parade magazine or something. Would they then have to put all California dispensers' addresses and license numbers in there? It appears so. And it could become burdensome. All right? You can't really do the advertising then. And it discriminates against the national or large organization. I think that's something to be considered in that. Yes?
My question is, right now, my question is the manufacturer put the addresses of all these offices? What is just put one single 1-800 number?
Yes.
I don't know if there is even jurisdiction on this advertising, because it says advertising by a person licensed to dispenser. The person who's putting this ad with the 800 number sitting in New York doesn't have.
I, or L, that L, any national advertisement run in California shall comply with California laws and regulations.
Yeah, I know, but
So it doesn't apply.
if they don't put, my question is that if they don't put any address, just 800, so people call to the 800 number. Now, when people call to the 800 number, the 800 number will give them a name and address, or they give you the lead.
They give us the lead, they transfer it. It's not, currently it's a hot transfer. They'll actually transfer
right
the
away.
client to us, or they'll give us the lead if it's after hours.
If I could just comment on the advertising issue with the.
Sure, please.
The advertising issue with the national corporations is that they're in California, they're advertising to our consumers. So as a board, we want to protect our consumers from these advertisements. If we have no control over them, and the licensing simply says, well, it's over there in, somebody in New York or Chicago or wherever, we have no control of them, that's a problem. And a lot of these corporations have contacted us and they're willing to work with us. So I know they want to comply with state laws. And having that information for the consumer to know, this is a licensee, this is a licensee's number, that helps us. And I don't think that's very uncommon with other professions.
It may be, but what I'm saying is,
I realize it might be burdensome and problematic.
yeah, I don't see realistically how that can be done. I just don't understand how you're going to spell that out.
There's not enough real estate in the ad. It's just not.
Yeah, there really is not enough in the ad. That's so. All right. And how do you enforce when people are advertising in California? It's interstate commerce quite often. So that's a concern.
And I think briefly as we go on, and we do appreciate the recommendation to carry this over with a smaller working group, but what's going to be the way to make this unburdensome and doable for the licensees in California who are franchisees of the large national chains like Miracle Ear and Costco, because it's going to happen more and more. And we want to make sure that if they are publishing an ad, that we can be compliant but simultaneously responsible to the board, as well as being able to run the advertisements to make sure that they're getting the customers that they need to see.
Yeah.
Is that all you have?
Sure. The only other thing that I would say is as far as Miracle Ear won't tell us what retail price is. This has already been discussed, but we don't. What we do is, what I've done for years is I refer to our posted price list, and in my offices I have a list price list on the wall, and I've had that for the last 20 years. So, because there is no miracle ear national price, prices are all 8%. Our cost is 8% higher in California because we have to pay sales tax and other states don't.
Thank you. I think that's very valuable input, and
Thanks.
the board would like to know more about this as we proceed with these regulations. I really do think it would be helpful. So thank you for that.
Okay, there is a motion on the floor, I believe. Is there any further discussion, comment from public members, board members? Okay, I'd like to call for the vote. Dee?
Aye.
Aye.
Aye. Aye. Okay, that motion carries. Thank you very much, Amnon and Marcia, for being volunteers to work on that. Yeah, serious.
We are now on item number 12, item number 11.
Oh,
So this is Audiology Practice Committee report.
yes, it is.
So we're going to cover item number 11, item number 12, 13, and 14.
Okay, thank you. This is a report on the Audiology Practice Committee. We met yesterday, and all of our members were in attendance. We approved the minutes of the August 11th meeting with minor edits. We sought public opinion or public comment on items not on the agenda. We discussed continuing professional development requirements, specifically a letter from audiologist Margaret Winter outlining her concerns about continuing professional development. And there was a motion to ask the full board for board action to amend the CPD regulations to clarify and simplify the requirements and allow dispensing audiologists to have more flexibility in achieving their continuing education hours. We also discussed challenges with California Children's Services Program. This is like a standing thing that we do at every meeting, right? Marcia prepared a very nice summary statement that kind of outlines many of the challenges of communicating with CCS. I noted, or I reported, that the data management system for the state of California is currently offline and has been offline since the beginning of December, which is causing vastly increased workload and possibility for error because we're reporting newborn hearing screening using paper pencil. Again, we discussed the challenges in understanding requirements for cochlear implantation in the CCS program, causing delay in implantation, shortage of pediatric audiologists providing services in the CCS system, and the sort of continued lack of responsiveness of the CCS head chiefs to talk to us about clarifying regulations and processes. We agreed that Marcia would discuss these issues with the lobbyists for the California Academy of Audiology, and Amnon offered assistance from HHP from their lobbyist, and noted that this wasn't you that said this. Who was this who said this? Noted that some hearing aid dispensers are CCS providers. Was that you?
No,
It was Vanessa. That's right. Yeah. Okay. That some CCS providers are hearing aid dispensers. So we're hoping that maybe the lobbyists can help us with our efforts to communicate with CCS. And this, of course, will also be a topic for our sunset review discussion. Is there anything that I've neglected to put on this report before I call for a motion to approve?
So there are then two separate motions to the full board on the table right now.
Yes.
So that the full board will need to vote.
Okay.
I just want to say that the statement prepared on CCS was developed by Allison and Becky and me. I had nothing to do with it, besides copying it and sending it in.
I feel like we've been having this conversation for so long. Yeah, I know. This is a really
I
nice
think you
subject.
guys
Okay, well, that explains why I like it so much.
I do,
We've been saying these same things for 40 years. It just kind of goes around and around. That's hysterical. Thanks. Okay, that being said, first we have to accept the report, and then we have to have the motions that the full board votes on, correct?
The motion to accept the report, right?
Yeah, I'm seeing nodding here. Okay, so first I would like to have a motion. Is there any other question or comment from public members? Okay, I would like to have a motion to accept this report as presented to the full board.
So moved. Second.
Okay, it's been moved and seconded that we accept this committee report to the full board. Can we have a roll call vote? Dee?
Yes.
Aye.
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 Okay, so the report is accepted. So now can we just go right ahead and make those?
So technically speaking, because it is coming from the committee that is comprised of 3 members, there's already a motion. So now we would just ask for public comment, and then there could be a roll call vote. It's already been motioned and
Oh,
seconded.
good. Okay. Once again, I would like to invite the public to make any comment that you would like to make on the report that I've just given, and specifically on those 2 motions. First, to amend the CPD regulations to clarify and simplify requirements to allow dispensing audiologists to, maybe the motion should just be more vague.
Actually, that wasn't, the motion was to delegate to staff to
Yes,
bring
okay,
back
thank you.
information
I love
on the
motions.
courses that are available to dispensing audiologists.
Good. I love motions to delegate to staff.
That's the trouble.
Definitely. Okay, so there's one. And then the other motion is, okay, let's just do that one first. Okay. Is there any further comment or question on delegating to the board staff to look at our CPD regulations?
What are they going to look at?
It's just the complexity and the nitpickiness.
Actually, Allison, can you clarify?
Yeah, that was.
So the motion was to delegate to staff to bring back information to the board on the courses that are available, because the question was, is this an issue? And we just want to identify what the problem is. So again, to be more brief, the motion is delegate to staff to bring information to the board regarding the courses that are available to dispensing audiologists on hearing aid dispensing.
And with that information, then we can continue a discussion of whether our regulations might be considered for
Right.
modification based on that information.
Right.
Who would like to make that motion?
The motion's already on the table.
Oh,
It's already
good.
been
That's so
voted
much
and
easier.
seconded.
Okay.
So now just be public comment and then a roll call vote.
Okay, I feel like I keep looking at you for more public comment. Okay, good. D.
Aye.
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 Okay, that first motion carries, and then our second motion is for,
It was 2. So do you want me to?
yes, please, tell me how I should word that question.
It was to delegate to Marcia and CAA to contact CCS on behalf of the full board in order to facilitate further discussion on the issues that were discussed.
Just clarification, Marcia, we're delegating to our board member, Marcia, to work with CAA.
Yes.
Okay.
About on all aspects of the challenges of working with the Department of Healthcare Services CCS program, of which cochlear implants is one, but not all.
I'm sorry if you said this in there, that I thought the job was to try to facilitate meetings or communication, open channels of communication with CCS.
With CCS, and you were going to talk with your lobbyist and possibly with the HHP lobbyist as well to try and move this process forward.
Yes, okay. That was kind of messy.
Yeah.
So there's a motion and a
There is a
second already.
motion. Okay, so, and public comment? Okay, take a roll call vote on the second motion.
Aye.
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 Aye, aye, aye. The motion, the motion carries.
Item number 12.
Okay. Okay, we will now have a report from Marcia on the board's development of the telecoil fact sheet for consumers, or general hearing aid fact sheet for consumers. And this, there's a copy of this in the board book, presumably under tab 12.
Yes.
Marcia, would you like this?
Well, let me say that what you're looking at here is a draft. Last year when we had a bill before us that had to do with kind of making sure that the board came forth with consumer-friendly information about T-coils, we thought, after looking at many other states, even provided some from HLAA, that there was a lot of information, T-coil being just one piece of information. So this was a quick draft of the kinds of information that we would want to put on a fact sheet and on the board website. I don't think it's particularly complete. I don't think it is as in-depth in some areas as it should be. So I would like to propose that we be allowed to work on this, and perhaps in concert with HLAA to come up with better language for a fact sheet that meets what they feel to be consumer-friendly information and important information, and that we all agree on here on the board.
Thanks, Marcia, and I would be happy to work on that with you as well. Would you like to make some comments?
The only comment I would make is it's not complete, but you know that.
Right.
So, and I'm on the board of
Can you speak up my phone, please?
Thank you.
And introduce yourself.
Yes, Tammy Berrien. I'm on the board of the HLAA California organization, so I'd be more than happy to take this as a starting point and try to boil it down and see what we come up with. So, and Marcia, so I would contact you.
Yes.
You're going to be the point of contact for that? Okay. So I'd like to get your email address.
Right.
Vanessa Kahina on behalf of HHP, and we'll be happy to work on this with you as well.
Great, thank you.
We don't need a motion.
Do we need to designate a subcommittee to do this work, or?
So it was already, we designated that last
Oh, we
time.
did?
Yeah, it was designated, and also the president, well, it was delegated to you, if I remember correctly.
Okay,
For analysis, okay, yeah. So the president has discretion to do that without the motion, so.
So I don't have to delegate myself, is that what you're saying?
Wow.
You don't have to do it here with the
Yeah, you do have to delegate yourself, but just not the motion.
Oh, I'm glad to hear that. Okay. We are moving now to item number 13, discussion and possible action regarding performance of tympanometry services and cerumen management by hearing aid dispensers and hearing aid dispensers scope practice.
Can I go over the materials that I have?
Yeah, please.
Okay.
I think that's 13 or 14.
No, you did not.
Okay.
So I've given everyone a handout,
Oh,
and I just want to clarify something. The topic of scope of practice, cerumen management, and tympanometry actually came up prior to a bill that was recently introduced. That's SB 198. SB 198 was introduced within the 10-day public posting period of our agenda, so we cannot take a position on SB 198 today. What we can talk about is what was actually noticed on our agenda, which is a topic in itself of the performance of tympanometry services and cerumen management by hearing aid dispensers and the hearing aid dispensers' scope of practice. So what you have before you is language that was presented to the Legislative Council. This is, I believe, Vanessa, this is identical to what's in the bill. Is that correct?
Currently.
Yes, that is correct. That is what's in print in what is now SB 198. And we will be thinking through amendments as well. So that's just for discussion. We can go into that later.
Thank you. One other thing. So as the board staff, we are asked to provide legislative analysis. Legislative analysis is a broad term, but analysis to the impact that this may have, the implementation of these changes would have to the board. So it's my job to go back to the Department of Consumer Affairs and provide them input. They're also doing legislative analysis on other impacts that it may have. For instance, even our database could be impacted. So someone from IT has to look at the fiscal impact of what that means. So I'm tasked to kind of look at all of this on behalf of the board. How does this impact the board? So what we're seeking is not specific with the legislation, but talking about this, the scope of practice and what hearing aid dispensers can and cannot do. Did I say that correctly, legal counsel?
So as I read this proposed language, I have several thoughts. I guess first, does this constitute an expansion of the scope of practice? And in my mind, it does. My second thought is, would we then have to test these things in the practical exam, which has some very significant fiscal implications? And my third thought is that tympanometry is not a hearing test, and it's completely unclear to me the value or how tympanometry is helpful or required or necessary as part of the testing for the purposes of fitting and dispensing hearing aids.
So I mean, state what's on my concerns.
Do we have any comments from the public on these proposals and changes?
Thank you, and we appreciate the ability to have this discussion now before we're sitting down to really discuss a piece of legislation. But Vanessa Kahina on behalf of the Hearing Healthcare Providers of California. I think, we are looking at two issues here, and HHP members have brought these two issues to us as their legislative advocates for a number of years now. And I'll start by going to room and management. There is a desire, they see it as a patient access issue. What could be one visit turns into 3 visits if they're referring out, if they're doing the fitting and testing. We agree about concerns about testing in the practical exam, and are open to suggestions about how to work that through. On tympanometry, there's also been a desire within HHP membership to be able to refer out to ENTs for more specialized procedures, but I'm happy to have Toby Hill here, who's our president and owns 2 practices in the Bay Area, who can talk more about the implications of and the desire of hearing aid dispensers to perform these 2 procedures.
Thank you. Toby Hill. I'm the president of HHP California, and I do have 2 practices in Walnut Creek and in Brentwood. And one of those practices is an ENT practice. One of the things that's come up over the years, is, especially from ENTs we refer to, when we have an airbone gap, we have a concern that a patient's not, there is some anomaly in the testing that we do, they're always asking for the tympanometry. And if they don't have it, then they have to refer them out to have an additional test done, which is going to take additional time and money from the patient to be billed for an additional hearing test and tympanometry and so on. And most of the ENTs I work with don't understand why we're not doing it. Also, for us to be able to do our job effectively, understanding middle ear, what's going on in there, it changes how we fit the hearing aid. If there is some non-compliance in the middle ear, we have to add additional gain to compensate for that. That we don't have, we're doing it blindly if we don't have that actual test. Okay. We can argue that, but I mean, that's from, Dr. Ruth Bentler and all the other folks that I've talked about this. We all had the same
If you're
agreement.
doing air and bone conduction testing as you're required to do, it answers that question right there.
Not always, because we all know that the bone conduction testing is subjective in that
What?
if it's subjective, because depending on how much tissue there is behind the ear, it may not get the actual accurate reading. Also, the bone oscillators don't stay in calibration as well as what you would with a tympanometer.
I would take that one step further and say that as someone who works with a lot of hearing aids, if you do DSL or NAL targets to verify your hearing aid fitting, to appropriately fit your hearing aids, those formulas require that you enter bone conduction thresholds
Right.
to estimate the additional gain and output that are required to meet your targets.
Right.
You're not going to get that from a tympanogram.
No, I understand. And
A
we're not saying
tympanogram is not a test of hearing, and hearing aid dispensers test hearing for the purpose of fitting and dispensing hearing aids. Tympanometry is not a test of hearing.
Well, I disagree, and most other states disagree as well. It's actually required in a lot of the other states in this country that they do tympanometry. In addition to that, it's also a referral tool for us as well, outside of just the air-bone testing that we do. And that's really the concept behind where this came from. And I was asked by numerous ENTs why we're not doing it, and this is, again, where did the conversation go? Probably 5 or 6 years ago. As far as if you want to go into sermon management. With sermon management, again, the same thing. We're trying, in our area especially, in the larger metropolitan areas, access to ENTs are very limited. We're looking at 3 and 4 months at times for patients to be able to get into the ENT. For mild cerumen, it's too much. It's just difficult for the ENTs to get in there to get to them. Most family physicians are not really qualified to do that. That's where we see the majority of the problems when they're doing lavage and they're having issues. Either one, they just continue to push the cerumen back into the canal, or they don't get it. Or they keep coming back to us and we have to keep sending them back out over and over again. Also, the ongoing care of people that are wearing hearing aids, as they're putting the hearing aids in their ear, they're pushing the cerumen back into the canal, which just causes it to plug up. It causes the hearing aids to stop functioning, so they're in our office over and over and over. And that's really the idea behind. Yes.
Can you clarify who is pushing the cerumen back into the?
I'm sorry. When the patient's taking their hearing aid and inserting it in their ear,
Okay.
yeah, the physical barrier of the device
Right.
into the ear pushes the cerumen
I'm
back.
referring to the lavage when that's performed.
Well, if it's done improperly, then they're hitting in the middle of where the cerumen is, and that's going to just force it back into the ear.
So in the medical office visits coming back to you something.
Correct. Yeah, and the majority of the people doing the lavage are either nurses or they're nurse practitioners or CNAs in some case that are doing the lavage, and they're not doing enough to have the expertise to understand how to get out. Or the primary care physician would look at the ear and go, "You're fine," but they come to us, I can't even see the TM at this point, much less be able to do a hearing test.
So I think those are our major points for now, and happy to answer any more questions or figure out how we might be able to continue a discussion on this.
If I may, Joe Dobrik. My career path has been a little bit different than a lot of people in here, in that when I started in this business, audiologists could not fit hearing aids. My education was done back in the Midwest, where I was working with 4 ear, nose, and throat specialists, and it was required that we did hypnometry or cerumen management. From 1988 to 1998, I was education chair for HHP in the state of California, and we did have hypnometry. We did have hypnometry classes, and we had cerumen management classes up until, I don't know, maybe 8-10 years ago was when it was said that it was a diagnostic procedure. We do a lot of referrals with doctors, and they do require hypnometry. And I have to have my audiologist come in to do the hypnometry in order to conform with your board. And personally, I don't think when we're looking at the safety of the consumer, I don't think that there's any issue there in regards to tympanometry. And it is a procedure that most of the doctors require when we send them in for referral. So, I mean, that's my opinion. And anything else, Masha?
I was wondering if you could speak to the notion it says demonstrate proficiency. I was just wondering what the thinking is on how that would be done.
Well, oops.
In writing the language, we wanted to be as certain as we could that consumers and patients wouldn't see any harm should the scope on cerumen management be expanded. So that was the original thing in the language. How we envision this is some sort of extra endorsement or certification. And that was just the original starting point with the bill language, is that it might have been included in the practical exam. And we still have a long ways to think through how that would happen. But it's really so that the patient is protected and we make sure that the hearing aid dispenser is proficient in the practice.
Which leads to my other question in terms of how you gain proficiency. What's the plan for that?
The plan for that was right now, IHS, International Hearing Society, has an actual course in cerumen management as well as tympanometry, which is an extra CEU. In essence, and I tried to get the verbiage of the actual table of contents to get to you today, but unfortunately there's just not enough time to get it. But it would actually be an additional CEU that would require someone going to a class of whatever it is, 4, 6, 8 hours, where they have to not only learn the coursework of how to interpret the information, whether or not to refer, as well as to physically do it. And it would be an in-person class where they would have to demonstrate the proficiency of it in order to get certification.
Would you recommend they go to one of these courses?
Yes,
a
absolutely.
Series of them?
Yeah, our further thinking is that it might be a requirement and that we would then work with the continuing education component within the board to certify that.
And the idea, we don't want to put an additional burden on the board. I'm on the committee to help write exam questions for our licensing board as well as MBC HIS. And a lot of the criteria in hearing aid dispensing, the distance learning program that IHS has, tympanometry is a major component of that. If you're board certified through MBC HIS, that is a major part of the questions that are on the test. So you have to understand how it works and be able to demonstrate or to discuss anyway how it's done, what the results are, how do you read a tympanogram, and so forth. So there's multiple steps that we can get continuing education is to continue the proficiency. IHS, Dr.
Venema?
Dr. Ted Venema is actually doing thank you, sorry, senior moment, is doing a webinar currently on interpreting the tympanometry and doing it as well. So there's we don't want to put that as and the language kind of came from CMA helping us to draft the verbiage so that we all don't want to run into the weeds with CMA, obviously. And we're open to whatever criteria. I don't want to add it to, number one, you don't need to demonstrate this in a practical exam because there's not enough time in a practical exam. Because I'm an examiner for that as well. It's difficult to get through everybody in that, but if we have an extracurricular CEU program, I think it would be sufficient to do so.
Thank you. Thank you for that discussion, and at this point, this is informational, and we'll continue to watch this SB 198 as it progresses through the processes. Are there any other questions from board members?
Are we discussing this today, or just giving this?
I mean, this is just an informational presentation, so I think that we're not going to take a position today. This is just informational.
So there's no discussion on one hand.
We're not going to have any motions. Yeah.
No, but the discussion.
You can talk.
Yeah. Okay. Yeah. Go. Would
Okay.
you like the microphone?
Yeah. I know that the audiologists that are allowed by their profession to do cerumen management, right?
That's
And not just dispensing audiologists, but audiologists, right?
Yes.
Am I correct?
Yeah.
Now my question is like this: what kind of practical experience an audiologist get? I mean, throughout his education, if they're on cerumen management. I mean, if there any subject, I don't vision a subject that come and they clean the ear. How does it work in the academy? The audiologist getting the knowledge or the permission for doing cerumen management?
I would defer the answer to that question to somebody who works in a training program. So if we had, I mean, I know you're working on a curriculum, but you're probably not there yet. If we had somebody from the San Diego program here at this meeting.
About your individual experience.
My own individual. Oh, go ahead.
Well, I think the question here is really on the topic of, I think before we get too much into the qualifications for audiology,
Yeah.
we can research that, we can find that out, but I don't want to get sidetracked and start talking about audiology qualifications, because the question really is
already in our
scope of practice with cerumen management, with hearing aid dispensers. I did have a question though, and something that would be helpful to me and my staff would be understanding the distinctions in what other states allow as far as tympanometry and as far as cerumen management, even just a list. I understand that there is some ambiguity, that it may not be clearly stated in some practice acts, but if I could at least know those that would allow me to do some research and gather some background information for the board.
I believe that we'll have that list in fairly short order, but because so many states have ambiguity, it's been difficult to harness it.
Okay.
And in our very strict interpretation of our own Practice Act, that's why we saw some of this language as necessary in wanting to actually have a conversation about it.
Okay. And Vanessa stated that they're going to be gathering that because there is some ambiguity. And I would say even if you have any draft information of some just quick information of where it is clear, if there's clarity in other states, that would be really helpful to me. Marcia, did you have a comment?
I do. Several comments and a question. I think Adnan's question is a fair one, and at some point we do need to talk about this and come face to face with that. The realities for audiology. I'll just make that statement. The other is we don't have reciprocity with a lot of states because their requirements don't meet our standards. So simply because there's a handful or a whole load of other states that allow certain things, I mean, Colorado, you can dispense hearing aids out of your car trunk. Does that mean they allow cerumen management? Are we going to buy into Colorado? My other question, though, is I'm wondering if you can tell me about the cerumen management courses. Do they include all aspects of that in terms of, is there curette training, is there lavage, is there suctioning? Are all those things going to be incorporated?
Yeah, they are, in that particular course, yes.
Okay, thank you.
Yep.
Okay, so we'll just keep our eyes on this as it moves forward. Thank you. I'd like to move to tab number, I believe it's 14. Yeah, Paul, you're going to talk to us about FDA guidance information.
Well, if you don't know by now, the FDA put out a news release on December 7th and put out a guidance document relating to hearing aid sales. And this is kind of a follow-up to the PCAST report from the previous administration on making hearing aid devices accessible to consumers. So the question has been, how does this affect our licensees? How does this affect California? And I asked Kelsey to do some research, read through these documents, and talking with our law how this affects us. So I'm going to let Kelsey talk a little bit about this document.
Okay, so first and foremost, these are non-binding recommendations. So it's really just letting the public and everybody know that the thought process of the FDA at this point in time. They have not formally repealed any of their regulations that they have, and so they are non-binding. So I wanted to first point that out. But what they are saying is that the FDA does not intend to enforce medical evaluation under 21 CFR 801.421A or record keeping under 21 CFR 801.421D. And so
That's D as in dog.
D as in dog. And I can read those for you briefly. The first one is that the hearing aid dispenser shall not sell a hearing aid unless the prospective user has presented to the hearing aid dispenser a written statement signed by a licensed physician that states that the patient's hearing loss has been medically evaluated and the patient may be considered a candidate for a hearing aid. The medical evaluation must have taken place within the preceding 6 months. So the thought process is that they're not going to be enforcing that regulation because they see it as a barrier to access. And just to give you a little bit of an overview of what that means in California, there's actually no similar requirement in California. So the second one is the waiver to the medical evaluations. And that is what was just discussed. If somebody is 18 years or older, they may waive that. But the hearing aid dispenser has to provide certain information in order for that to be waived. The FDA has concluded that many patients over 18 are actually waiving that, and so the necessity is not really there anymore. In California, actually our requirement is 16, and we actually have an exemption under the federal statutes for that. So it doesn't really affect us either. So we actually have, under their list of exemptions, we have the exemption to, and 16 is obviously less stringent than 18, so that aspect does not really affect California. And then the last one is subsection D, which is record keeping. And the dispenser shall retain for 3 years after the dispensing of a hearing aid a copy of any written statement from a physician required under paragraph A1 or A2 of this section. So it was essentially ensuring that they keep for 3 years records of either the waiver or the physician statement. And again, because that really doesn't affect us in California because we don't have similar issues, the non-enforcement of subsection D does not really change the course of California law.
Are there any questions from the board or anyone regarding this? Yes.
You probably know that Senator Grassley and Warren are about to introduce their bill into the 115th Congress, making this law. Yeah, so no longer will it be a recommendation.
Who's the senior author? I'm sorry, did you say Grassley?
Yeah, I'm not sure if it's Grassley or Warren. Actually, it says
Oh,
Warren.
okay, so it's
They're
Grassley.
They're co-sponsors.
They're co-sponsoring this bill, but it has not been introduced because there's no bill number yet.
They don't talk to each other.
Well, they did introduce it in the last Congress, but it didn't. It's too late.
And everyone is so involved with the ACA issues that it kind of is taking a back seat to that right now. But they think it will eventually, and there's pretty positive feeling that it will pass. In the meantime, the American Academy of Audiology has come out with their own 2 sets of guidelines, interpretations and guidelines that I think might be helpful to us down the road if we decide to look at this law and see if there are any regulatory changes we want to oppose based on some of those recommendations, because they're fairly reasonable. It's kind of like if you can't beat them, join them. And if so, here's the best way to do it.
Any other questions? I think we were just replying to the immediate effectiveness document, but thank you.
Any comments from members of the public? Okay. Thank you.
I think we probably need to go to February quick just to select if we need to go into number 10, which is an overview education.
Yes, okay, we're gonna take a 5-minute break and we will reconvene no later than 2:15. Thank you.